All right, good afternoon. I know we're a couple of minutes before 4 o'clock, but by my count, I think we have everyone here. Good afternoon. I know it's an awkward thing where the live stream echoes you. I don't just repeat myself. Hello, Mr. Nibs.
Hello, Judge. How are you today?
I'm well, thanks. How are you?
Good, thank you. I'll try to get my lighting a little better.
No, you're fine. Mr. Nibs, are you ready to proceed?
Yes.
Okay. And I see that we had Miss Hanselman, our other juror. She stepped away. That's no problem. But I thought I'd see if she's ready to begin. And if not, we'll give her a few minutes. Oh, there she is. Hello, Miss Hanselman. How are you?
Hello. Good afternoon, everyone.
Hey. All right. And it looks like we have all advocates, and I can see them identified by name. And is everyone's witnesses present before we call the case, just informally off the record?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, great. So a couple of things, again, before we go on the record, that we learned last night is in terms of videos staying on and off during the case. Because we are live streaming and because I know there's participants watching, the consensus is that during openings and closings, if everyone can keep their cameras off unless you're giving the opening, so if the plaintiff is giving their opening in your defense, you can leave your camera on. And then and the same thing for closing. And during examinations, all advocates should keep their cameras turned on, even if it's not your witness. And we're going to keep everything in grid view for purposes of viewing. I was sort of jumping around a little bit last night and our technology was failing just a bit. And so sometimes I'll talk to our jurors to see if you need a break or something like that. And it's up to you if you want to turn your video on or if you just want to unmute your computer instead. I'll just try to check in to see if anyone does need a restroom break. And if any of our jurors do, feel free to pop on and interrupt too. That's no problem at all. So I think for logistics, that's really all I had. We'll obviously formally enter appearances and cover preliminary matters with the advocates. Before we get to that stage, though, again, off the record, is there anything I haven't covered regarding cameras or anything like that?
Just to clarify, Your Honor, did you say you want us all keeping our videos on when someone else is giving a direct, even if we're not the opposing witness? Excuse me, the advocate?
That is the direction I've received, yes.
Okay, thank you.
You're welcome. All right, anything else with that front?
Did you want the jurors to be off like last night?
Yes, please.
Okay.
That is a request. So if our jurors could keep their cameras off, that would be great. Thank you.
Definitely. Don't want to scare anybody.
Then you don't have to worry about your lighting. So.
Oh, shoot. Is that okay to have a picture or that? I don't know.
Yeah, you know, I have mine set up so that if you have a picture default, mine has that as well, that it doesn't interrupt anything. So totally fine.
Okay.
The only other thing is, as you all know, it's a locked room. We had some participants coming and going last night, and I wasn't trying to interrupt people, but we're trying to make sure that we're not having anyone present who shouldn't be. So I may pause if there's someone in the waiting room to see if it is a witness that needs to be let in. I think most of those logistics kind of worked themselves out last night too, so it shouldn't be too big of a deal. But if that pops up, it was a question. All right. Well, with that, we're obviously here for the second round of the 2020 Summit Cup. If I can please get an entry of appearance beginning with the plaintiff.
Yes, Your Honor. My name is Olivia Hall, and I, along with my co-counsel, Ms. Taylor Sims, represent the plaintiff, Cam Donaldson. We are ready to proceed with motion in limines pursuant to a couple of housekeeping matters, which I will be handling, and a motion in limine in 2 parts, which my co-counsel will be handling.
Okay. Oh, and I've just had a request from Jack Hall to enter the waiting room. Is anyone familiar with that individual?
That's my dad. Just go ahead and deny it. He went to the wrong place, I guess. I didn't even know he was going to watch, but I'm sorry about that, Your Honor.
No, don't apologize. He should be able to get on the YouTube, hopefully. So I'm going to kick him out.
Okay.
And I'm sorry, I need just a minute. I've accidentally written down my parties wrong here. So Snowmass is Miss Hall and Miss Sims. I got to start over.
Your Honor, I believe one of our witnesses is actually in the waiting room. Her name is Gada, and she will be playing Cam Donaldson.
I don't have anybody in the waiting room.
Okay, well, stay tuned for that.
That's fine, no problem. All right, so Miss Sims. All right, and an entry of appearance. There we go. We did have one person in the waiting room. Sorry, Cam Donaldson. Okay, all right, and entries of appearance, please, from the defense.
Good afternoon, Your Honor. My name is Lauren Doig, and I'm on Team Montero, along with my co-counsel,
Vladimir Dorosh.
and we represent Ms. Karen Baja in today's case.
All right, great. Do either of our jurors have any kind of conflict that we need to be concerned about? If you just want to turn on your microphone and let me know if you're good to go.
I have no conflict, Your Honor.
Thank you.
This is Lisa Hanselman, no conflict.
Thank you, Ms. Hansman. All right. In that case, if we can please have everyone raise their right hand for the swearing in, indicate I do. If you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
Great. All right, we are now calling case 2008-2263 Cam Donaldson versus Karen Baja. Let's begin with any preliminary or housekeeping matters. I'll start with the plaintiff, please.
Yes, Your Honor. May we assume all witnesses are pre-sworn?
Yes.
The exhibits are not pre-marked. May we refer to them by their page number in the electronic file when identifying them, but before marking them?
That's fine.
Also, when identifying those exhibits, would Your Honor like for us to drop a copy of the exhibit in the chat, or is it okay if we just cite to the page number?
I think citing to the page number is fine. Our jurors don't have access to any type of electronic notebook. If it's something that you would want them to see because it's been admitted, obviously you can utilize screen sharing. But in terms of referring witnesses to anything, there's no need to share that information in the chat.
Yes, Your Honor. Now, pursuant to local rules, co-counsel may perform the role of trial technician. And as such, Ms. Sims is going to be handling the screen share responsibilities for me during my closing argument and examinations. And I'm going to do the same for her during her opening statement and examinations.
That's fine.
And Your Honor, if it becomes necessary to mark an exhibit for demonstrative purposes only, may we ask the witness to do the marking?
I think that's fine. Obviously, if opposing counsel has any, substantive objection to the nature of the markings, they can make it, but I don't have any problem, again, if it's appropriate, allowing witnesses to mark demonstratives or things like that.
We have no objection to that, Your Honor. And even if it's easier to constructively mark, I know some of these witnesses are less familiar with Zoom. We don't have a problem with that as well.
Great.
There are certain stipulations contained in the file. May we read those to the jury when they become relevant?
That's fine.
And Your Honor, Lou Donaldson was declared legally dead on August 18th, 2017. As such, we request that the court take judicial notice of the fact that Mr. Donaldson has been declared legally dead.
Pursuant to what rule?
615, I believe.
Is there any objection from the defense regarding the court taking judicial notice of this death certificate?
Your Honor, there's not a death certificate in today's case, and I believe the rule that opposing counsel is referring to is the sequestration of witnesses. It is stipulated that in probate court, he was legally declared dead. And if they would like to read that stipulation, we of course have no objection to that.
I think I may have misstated. I think I said death certificate, and I don't think that's what Ms. Hall asked me. Can you repeat your request, Ms. Hall, so I to clarify the record?
Yes, Your Honor. We're only asking that the court take judicial notice of the fact that Mr. Donaldson has been declared legally dead by this court.
Okay. And again, I think I misspoke. Is it Ms. Doig?
Yes, Your Honor, that's correct.
Okay. And tell me again your objection, Ms. Doig.
Your Honor, the probate court declared Mr. Donaldson legally dead for the purposes of a will, and we have no problem if the opposing counsel would like to read a stipulation to that effect, which we have made, but to take judicial notice that they have met one of the elements that they need to prove in today's case, we would object to that.
Your Honor, may I respond?
Sure.
Your Honor, we are asking for judicial notice that he was declared legally dead, not that the defendant killed him.
And this is, can you point the court to the stipulation or the findings specifically regarding the declaration of death?
We have it in the complaint, Your Honor. I don't think that there was a stipulation to, or I'm not really familiar with the stipulation that opposing counsel is referring to because it's not in the stipulation packet, but
I can refer to it if it's easier. It's number 16 in the complaint, which we did admit. On August 18th, 2017, defendant filed a motion to have the probate court of Statesville declare the victim to be deceased. The probate court of Statesville granted defendant's motion to declare the victim as being deceased. Your Honor, we have no problem if opposing counsel would like to read that to the jury. However, this is not probate court, and this was not something that you made judicial notice of or this court made judicial notice of.
I'm looking at Rule 201B1, and the court may take judicial notice of a fact that is not subject to reasonable dispute if it is known within the trial court's territorial jurisdiction. So I agree with you. I am not the probate judge. I'm a criminal judge. However, if it's Statesville, that would be within my jurisdiction. I don't know if there's really substantively a large difference between me taking judicial notice of something and something being advised to the jury. The main thing would likely be a jury instruction. And so I'm going to hold off on that. I think it's a fairly legitimate request, but ultimately I don't feel comfortable drafting or changing any of the jury instructions at this point. I'm not prohibiting by any means the plaintiff from, again, drawing the jury's attention to this if the, and I said a criminal judge, I'm a civil judge. Since again, as Ms. Doig stated, they in their response agreed with that allegation in the complaint. So it doesn't seem like it's a fact of much dispute, the declaration of death. But I'm not going to modify jury instructions at this stage, which I think would be the main outcome of a judicially noticed fact. It's likely appropriate, but since there's been an objection, I'm going to deny it just to keep the record clear.
Yes, Your Honor. Would you like for us to formally tender our experts or lay the foundation and move on?
I appreciate a formal tender, please.
And Your Honor, because we are not in a courtroom, may we be asked to be heard outside of the jury for any kind of sidebars?
Of course.
And may we assume that those sidebars are constructive for the benefit of the scoring judges?
Yes.
Your Honor, normally we would invoke the rule. However, all witnesses are either parties or experts, and therefore we will not be invoking the rule.
Okay, that's fine.
Your Honor, we remind the court that this trial is not bifurcated and that we must prove damages.
Okay.
And lastly, we have agreed with opposing counsel to exclude the pictures of the airplane and the water found in the electronic record on pages 61 and 62.
All right, stipulated that the parties will not bring forward, which were the exhibits, please?
They're the exhibits on page 61 and 62 of the floating parts of debris in the water.
Is that correct, Ms. Doig?
That's correct.
Okay. And it's 2 photos?
Yes, Your Honor.
Okay. Any other preliminary matters from the plaintiff?
No, Your Honor, that concludes our preliminary matters and we're ready to move on with motions in limine.
Okay. Any preliminary issues for the defense before we get to motions?
Yes, Your Honor. I just would like the court's permission to use the share screen function when we're displaying an exhibit for the jury.
That's fine.
And Your Honor, I'm just trying to see if, I think they actually covered everything else. The only other thing I was going to say is that our trial technician, Mr. Jones, is also on here. His video is off, so you may not be able to see him, but he will be doing the technology for myself and my co-counsel.
Any objection to that from the plaintiff?
No, Your Honor, we have no objection to that.
Okay.
Your Honor, we do have a PowerPoint that my co-counsel plans to use on his opening statement. We already told the plaintiff what the contents of that PowerPoint are, and as far as I know, they don't have an issue with that.
Was that correct, Ms. Sims or Ms. Hall?
Yes,
We
Your
have
Honor.
no issue with that.
Okay. No problem. I'm fine with that. Anything else before motions, Ms. Doig?
No, Your Honor.
All right, let's start with any substantive motions for the plaintiff, please.
Yes, Your Honor. This is a wrongful death case in which we are suing the defendant for intentionally or recklessly causing the death of Lou Donaldson, Cam Donaldson's father. Lou Donaldson was last seen alive by his daughter on August 17th, 2012. The defendant petitioned to have Mr. Donaldson declared legally dead on August 18th, 2017, and plaintiff has one motion in limine.
Okay, please.
First, Your Honor, plaintiff moves to exclude any mention of an alleged mistress of Mr. Donaldson. The defendant claims that Mr. Donaldson told her that he had a mistress in Costa Rica. Specifically, on page 44 of the record, the defendant said in her deposition, he had a mistress in Costa Rica. It is something we had spoken about and were working through. Therefore, plaintiff moves to exclude any mention of this alleged mistress as hearsay.
Okay. Response to the hearsay objection to this testimony from the defense.
Yes, Your Honor. It's our contention that Ms. Baja did not kill her husband, and instead the evidence will show that Mr. Donaldson did have a mistress in another country and likely died in a plane crash going to visit her. This testimony elicited, we do intend to elicit it, is not hearsay. Ms. Baja was Mr. Donaldson's wife, and they were talking about this conversation together. Additionally, a statement by Mr. Donaldson that he had a mistress is a statement against interest. Mr. Donaldson is an unavailable witness, and for him to confess to his wife that he was having an affair when there's the possibility of divorce proceedings, which we have a good faith basis opposing counsel will get into, goes to show that this is against his interest.
Okay. Ms. Sims, in regards to 804.
Yes, Your Honor. One moment. Your Honor, this exception does not apply here as it is a civil case. Additionally, the record is silent as to how Ms. Baja, the defendant, learned of this mistress. And the only thing that it does say is that they had spoken about it. Therefore, the only way she would have any knowledge of the mistress would be through Mr. Donaldson telling her about this alleged mistress. Therefore, this evidence is purely derived from hearsay and there is no qualifying exception.
Your Honor, if I may be heard.
Okay.
As the court knows, this exception is not only applicable in criminal cases, but it's applicable in civil cases as well. Opposing counsel already read a statement of the deposition where she said that Mr. Donaldson told Ms. Baja that he had a mistress. He is an unavailable witness, and this is a statement against his interest, as eliciting that testimony that he had an affair could affect a no-fault divorce proceeding.
I tend to agree with the defense that this could be a statement against interest because it could, in fact, open him up to some type of pecuniary liability. So I'm going to deny the motion to exclude that information at this time.
Yes, Your Honor.
Any additional, I think you said just one motion. Was that right, Ms. Sims?
Yes, Your Honor. We already agreed to the second motion in limine.
Perfect. Any other motions then by the defense?
Yes, Your Honor. Before I begin with my motions, I'll also say that we did agree with the plaintiff that no mention of whether or not Ms. Baja took a polygraph in today's case will be coming into evidence.
Okay.
Your Honor, 2 months before the deceased was last seen alive, he filed for a temporary restraining order that was denied by the court, in which he made allegations against his wife, Ms. Baja. May I show this temporary restraining order on the screen?
I'm actually familiar with it, so that's not necessary, but thank you.
Honor. This document is inadmissible hearsay, and any use of this by the plaintiff would only be for propensity.
So you're moving to exclude it under due to hearsay and 404?
Yes, Your Honor.
Okay. Response to that?
Your Honor, Mr. Donaldson was declared dead and therefore is not available. Furthermore, we have alleged and will prove that the defendant wrongfully caused his death. As such, pursuant to 804B6, Mr. Donaldson's petition for restraining order is admissible as a statement offered against a party that wrongfully caused his death or unavailability.
Okay. And what about the 404? I'm candidly less concerned about the hearsay as I am the propensity.
Could I, what exactly, I was a little unclear on the 404 argument. If I may ask opposing counsel, just.
I think the argument is that because Mr. Donaldson allegedly was afraid of Miss Baja at that time, that therefore she must have committed been the cause of his death, is my understanding. But Ms. Doig, is that correct or no?
Yes, Your Honor.
Your Honor, this is clearly this is clearly admissible, and there's no propensity here. We're arguing that Mr. Donaldson was declared dead and his statements need to come in because the jury needs to see that what his state of mind was at the time of the petition for a restraining order was filed.
Your Honor, may I respond?
I'm not right now. I'm leaning towards granting the motion to exclude. I'd like to wait on that though, to see how things play out a little bit. Because I don't want to grant that motion right now without having a little bit more context. And so I'm going to deny the defense motion at this time. However, I would ask the plaintiff not mention it in opening and not go into this testimony in front of the jury and just approach instead, so that we can address it again, since I know that this is obviously an important piece of evidence, but something that would be hard to unring. So I'm going to withhold ruling on that. Any clarification about that ruling?
So we can't use it in opening statements, but we can ask for a sidebar before, any direct or cross-examination that we wish to bring it up in.
Yes, ma'am.
Yes, Your Honor. Okay, thank you.
You're welcome. Any other motions from the defense?
Yes, Your Honor. Our next motion concerns a statement we anticipate the plaintiff will testify to regarding what Mr. Donaldson allegedly said after getting into a verbal disagreement with his wife. According to the plaintiff, after this fight, Mr. Donaldson told the plaintiff, "If anything were to happen to me, have the police look at Karen because she will be the one responsible for my death." This is inadmissible hearsay, Your Honor. It's not an excited utterance because this statement was allegedly made after a verbal argument between husband and wife. And the most foundation that can be laid is that Mr. Donaldson looked shaken. Verbal arguments between spouses are not the type of exciting events that this rule or this exception to hearsay were meant for, like a shooting or an explosion. Shaken is not enough to show that he was so overwhelmed he couldn't think clearly.
Okay. Response from the plaintiff.
Your Honor, his spouse had just threatened to kill him, to end his life. This is clearly excited utterance under 803(2) because it's a statement that relates to a startling event or condition, and any reasonable person would be startled and under the state of excitement if their spouse of 11 years threatened to kill them. Furthermore, he was still under the stress of excitement when he had told Cam Donaldson to look at the defendant if anything ever happened to him.
Okay. So I'm actually going to have you hold off there for a second, Ms. Joy. We need to see the foundation to know if it was an excited utterance. I think it's going to depend on how the witness testifies. Based on the offer of proof from the plaintiff, I'm going to deny that motion right now. However, Ms. Stoy, you can re-raise that objection during the trial if you don't feel the foundation is sufficient for an excited utterance. But I think at this time, it's without hearing the foundation, it would be too soon for me to grant that kind of type of a motion. So I'm going to deny it.
Yes, Your Honor.
Any additional motions?
No, Your Honor. With that, the defense is ready to proceed.
Okay, great. All right. And just a reminder, if you are not giving the opening, if you can please pause your video, and I will turn to the plaintiff for opening statements. Ms. Sims,
Your
thank you.
Honor, may I ask one point of clarification real quick?
Sure.
Regarding defendant's second motion in limine, I know you said you will reserve ruling until a foundation has been laid. Is there enough of a good faith basis to refer to that statement during opening statements?
The regarding Mr. Donaldson's statement to look at Ms. Baja,
Yes, Your Honor.
you can include that in your opening statement. That's fine. I denied it. Thank you.
Ready to proceed, Your Honor.
Go right ahead.
When faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. She killed her husband to keep her status, killed her husband to keep his business, killed her husband to keep his money. The defendant's husband was Lou Donaldson, a self-made man who built himself a fortune from the ground up. Mr. Donaldson's true passion was always animals, especially big cats like lions, tigers, leopards. That's why he opened Wild Wildlife, a big cat sanctuary, where he works side by side with his only child, his daughter, Cam. I'd like you to meet Cam right now. Cam, will you please turn your camera on? For 20 years, Cam worked side by side with her dad at Wild Wildlife, scheduling his meetings, managing the office, running the books. Cam and Mr. Donaldson share that special bond between father and daughter, a bond that only grew stronger over the years as they worked side by side together. Thank you, Cam. You can turn your camera off now. Mr. Donaldson met the defendant one night when she was out hitchhiking. He pulled over, he picked her up, and they had a one-night stand. The defendant was a younger woman, 20 years younger than Mr. Donaldson, who admits that she came from nothing. But now that she had met a rich, older man, she was not going to let him get away. And she convinced Mr. Donaldson to marry her. But by the summer of 2012, the defendant's marriage was in trouble. We will call Cam today to tell you that just 2 weeks before her father's disappearance, she heard screaming coming from her dad's office when her father told the defendant he wanted a divorce. The defendant was furious, screaming. She threw open the door and stormed out of Mr. Donaldson's office. Lou Donaldson was not going to take everything away from this defendant and put her back on the streets. Moments later, Lou Donaldson came out of his office. He was upset, scared, and shaking. Looking over at Cam, Mr. Donaldson said the words Cam will never be able to forget. If anything ever happens to me, be sure to have the police look into Karen. She will be the one responsible for my death. Just 2 weeks later, Lou Donaldson disappeared, never to be seen again. We brought this case on behalf of Cam Donaldson against the defendant for the wrongful death of Lou Donaldson. As the plaintiff, we bear the burden today of proving to you that Lou Donaldson is dead, the defendant caused Lou Donaldson's death, and caused Cam to suffer injuries as a result. I will be the first to tell you, Lou Donaldson's body has never been found, which means that this is a case based on circumstantial evidence. But you will learn today that the law makes no distinction between direct evidence and circumstantial evidence. Therefore, we will show you through several circumstances today that will prove the defendant killed Lou Donaldson, starting with the last time Cam saw her father alive. On Friday, August 17th, 2012, Mr. Donaldson was leaving his office for the weekend. He asked Cam if she wanted to come by for Sunday dinner. Mr. Donaldson did not tell Cam that he was leaving or going on a trip or flying away on one of his planes. He planned to be in town. But Cam never got to have that dinner with her dad. Instead, Cam had to respond to a burglary alarm that went off at the Wildlife office early Sunday morning. It was around 6 a.m. when the alarm went off, and Cam immediately drove over with the police right behind her. Cam will tell you what she saw when she got there. The lock on the front gate had been cut off, back entrance broken into and destroyed. And then the defendant came outside, holding a lockbox in her hands, with a man Cam had never seen before. And the man was carrying a pair of lock cutters. Now, the police tried to question the defendant about the burglary that night, but she told the police, "I'm the owner of Wildlife. If you have any questions for me, contact my attorney." You see, the defendant was claiming to be the owner of Wildlife before anyone even knew Lou Donaldson was missing. Since he disappeared, the defendant has claimed Mr. Donaldson must have flown off to Costa Rica. But we will show you that through the defendant's actions, she knew Lou Donaldson could not and would not ever be able to come back home. Just a few days after Lou Donaldson disappeared, the defendant fired Cam from Wildlife. Before Lou could have returned from Costa Rica, before an investigation into Mr. Donaldson's death and disappearance could have ever been completed. And then a few days later, the defendant produced what she claims is Mr. Donaldson's will. We will show you today that the circumstances around that will prove she killed Lou Donaldson. First, the lockbox the defendant carried away that night at Wildlife, it contained Lou Donaldson's actual will. Cam will tell you that she has not seen that will since. Second, the will produced by the defendant left everything to the defendant, leaving nothing for Lou's only child, Cam, that he worked for 20 years side by side with at Wildlife. Third, we will call Taylor Pride, who is a forensic document examiner and is trained to detect forged signatures and has investigated hundreds of wills. Mr. Pride will tell you today that the signature on the will the defendant produced was not signed by Lou Donaldson, and that will is a forgery. Lastly, Mr. Pride will tell you that this will contain language he has never seen before. Language that left the defendant Mr. Donaldson's entire estate should he die or disappear. We will also show you that this defendant had the means to dispose of Mr. Donaldson's body. At Wildlife, they use a meat grinder to feed the cats. This meat grinder is big enough to grind up a cow or dispose of a human body. This meat grinder is so big that it takes 2 people to even use it. And you will learn that in the early hours of Sunday, August 19, 2012, the defendant was not alone. At 3 a.m., just a few hours before Cam saw the defendant with some strange man at Wildlife, the defendant was with her brother, who is a deputy sheriff at the same sheriff's department that investigated Mr. Donaldson's death. Today, we will show you the threats, the burglary, the defendant's actions the weekend of Mr. Donaldson's disappearance. The defendant had the means, opportunity, and the help to dispose of Mr. Donaldson's body. All of the circumstances that prove the defendant killed Lou Donaldson. When faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. The defendant is responsible for Lou Donaldson's death. Find the defendant responsible.
All right. Thank you, Ms. Sims. Is it Darash, or can you say your name for me again? I'm sorry.
Mr. Dorash is good.
Darash. Perfect. Whenever you're ready, sir.
Your Honor, may I proceed?
Yes.
One of the greatest things about the United States is that here courts are for facts and not for fiction. It is a fact that Lou Donaldson disappeared 8 years ago. It is a fact that after 5 years of waiting for her husband to return, Karen Baja asked the court to declare him legally dead. It is a fact that Lou Donaldson's death is a tragedy. However, members of the jury, what is fiction is that Karen Baja had anything to do with his death. In fact, I would like you to meet Karen Baja. Ms. Baja, would you mind turning your video feed on? Members of the jury, this is Karen Baja. She lives right here in Statesville, and she runs Wild Wildlife, a big cat emporium that, by the way, she created along her husband, Lou Donaldson. Even when Lou Donaldson went missing 8 years ago, she kept doing exactly what Lou wanted her to do. She kept taking care of big cats. However, instead of sharing this grief together, her stepdaughter, Cam Donaldson, is falsely accusing her in killing her husband. A claim that is outrageous and, as the evidence will show, absurd. Thank you, Ms. Baja. Now, because plaintiff is the one who brings the claim to court, they have what's called a burden of proof. They will have to show you, by preponderance of the evidence, that Karen Baja killed her husband. And they will not be able to meet this burden today, at least not with facts. It will become clear to you if you keep these 3 things in mind throughout today's trial. First, Karen Baja did not kill her husband. Second, it is more likely that Lou Donaldson died in a plane crash. And third, Lou Donaldson's will ensured that Wild Wildlife was always taken care of. With that, I would like to move to my first point. Karen Baja did not kill her husband. And when the plaintiff alleges the opposite, they need to show proof. Well, as you listen to the case today, ask yourself, is there proof? If Karen Baja did kill her husband, how did she do it? Where is his body? These questions will not be answered by the end of today's trial. In fact, plaintiff will not bring a single shred of physical evidence that would tie Karen Baja to the mysterious murder theory. And what the plaintiff will do instead? They will spin the tale of fiction and ask you to believe that Karen Baja put her husband through a meat grinder and then fed him to the cats. Ladies and gentlemen, plaintiff's theory indeed sounds like some crazy Netflix series. But this is Courtroom, and this is real life. And courts are for facts and not for fiction. With that, I would move to my second point. The facts, the real facts, will actually point us out to a different conclusion, that it is more likely than not that Lou Donaldson died in a plane crash. Ladies and gentlemen, you will learn that Lou was a pilot. He owned multiple planes. He kept them at different airstrips. And till today, we don't really know the exact number of planes he had. He was also one of these pilots who disregarded simple safety measures. He used to fly without logging a flight plan, and he used to fly without a valid pilot's license. In fact, you will learn that his pilot's license was suspended months leading up to his disappearance. Now, we will not be able to show that plaintiff died in a plane crash on 17th or 18th of August, but we don't have to. It is not our burden of proof. It is plaintiff's burden of proof. But what we will do is we will come up with evidence and show that his van was found next to an airstrip a week later. The relationship between Karen Baja and Lou Donaldson was strained, and we will not be hiding that from you. In fact, Karen Baja will look you in the eye and will testify that their marriage had problems. She knew Lou Donaldson had a mistress in Costa Rica. She also knew that he had all the means to fly there whenever he wanted, by just hopping into one of his planes. However, Lou Donaldson's will had a different purpose, which brings me to my third key point. Lou Donaldson's will ensured that wildlife was always taken care of. Members of the jury, shortly after Lou Donaldson met Karen Baja, they founded Wildlife together. It was Lou Donaldson's passion, as the plaintiff mentioned in their opening, to rescue the large cats and to take care of them, which is why he invested a lot of money that he was able to save up until this time. 11 years of marriage to Karen Baja, they worked day into day together to make sure that Wildlife was a success. And they did. It turned out to be a success. Lou Donaldson wanted his legacy to carry on, and the person that he trusted the most with this task was Karen Baja, which is why his will ensured that she had all the means to carry on the work, which is exactly what she did. 8 years after his disappearance, and she is still day into day at Wildlife, making sure it remains to be a success. Members of the jury, defense is sympathetic with Cam Donaldson's grief. But she's not the only one who is missing her father's love and companionship. Karen Baja is going through the same struggle. She also misses him every day. However, the truth is, this lawsuit will neither bring Lou Donaldson back to life, nor will it provide answers to the questions that Cam Donaldson is seeking answers for. Because the idea that Karen Baja had anything to do with the disappearance of her husband is nothing more than a fictional tale. But courts are for facts and not for fiction. Which is why, by the end of today's trial, my co-counsel, Lauren Doig, will return to you and ask you to to return the only verdict based on facts. The verdict of not liable. Thank you.
Thank you, Mr. Duresh. All right, is the plaintiff prepared to call the first witness?
Yes, Your Honor. Plaintiff calls Cam Donaldson. Will you please introduce yourself to us?
I'm Cam Donaldson.
Cam, tell me what your family was like.
It was always just me, my mom, and my dad. That's why me and dad were so close.
What was your dad's name?
Lou Donaldson.
What was your dad like?
He was a good man, a self-made man. He didn't have much formal education, but he really worked from the ground up.
What did your dad do for a living?
Well, he started off by selling used cars, but animals were always his true love. Once he saved up enough money, he opened Wild Wildlife.
What is Wild Wildlife?
It was a sanctuary for big cats. We had lions, tigers, leopards, and more.
You said we. Did you ever work there as well?
Yes, I worked there side by side with him for 20 years.
What was your role there?
Officially, I was dad's assistant, but he used to joke that I knew more about the business than he did because I did just about everything. I scheduled dad's meetings, I wrote the checks, I answered the phones, I ordered all the supplies, and I ran the books. I really did it all.
Are you still working at Wild Wildlife?
No, I'm not. The defendant fired me days after my dad allegedly went missing.
Who is the defendant?
Karen. She's the woman that my father married, who I believe is responsible for his death.
When did your father die?
Well, Karen had him declared legally dead on August 18th of 2017.
When was the last time you saw your father?
I last saw him on August 17th, 2012, when he was leaving the office that Friday for the weekend.
When you saw him, did you have a conversation?
Yes, he invited me to dinner on Sunday.
During that conversation, did your father make any mention of plans to travel out of the country?
No, he did not.
Are you aware the defendant is claiming your dad flew himself to Costa Rica?
Well, I am aware, but that just would not have been possible.
Why is that impossible?
Because they found his van parked at an airstrip with his glasses and his keys inside.
Your Honor, I will object to speculation.
What's your response to the speculation objection, Ms. Sims?
Your Honor, this witness does have personal knowledge of her father's flight habits and his need to wear glasses when flying.
If I may briefly respond, I believe because of Zoom problems, my objection was a little late. I was objecting to the response that it would be impossible.
Your Honor, may I rephrase?
You may, because I think I would sustain that objection. I'm not sure that it's within this witness's purview if it'd be possible or impossible, but you can rephrase, so sustained.
How did your father usually fly?
He always flew with his glasses on. He was blind as a bat, and he couldn't do anything without his glasses, let alone fly a plane.
Did your father keep any of his planes at the airstrip his van was found at?
No, he did not.
Earlier, you mentioned that it was your job to maintain the books at Wild Wildlife. Did you also have access to your father's personal financial records?
Yes, I did. I had records of his credit card, his ATM, his financial accounts.
Your Honor, at this time, I'm citing opposing counsel and the witness to page 54 of the record. I'm marking that as Plaintiff's Exhibit 1. Cam, can you tell me what this is?
Those are Dad's bank statements.
Does this accurately reflect your father's bank statements?
Yes.
Your Honor, at this time, plaintiff offers Plaintiff's Exhibit 1 into evidence.
Is there any objection or voir dire, Mr. Duresh?
No objection to entering this into the evidence.
Okay, Exhibit 1 shall be admitted.
Your Honor, may I publish this by sharing my screen?
Yes.
Looking at your father's bank statements, when was the last time any money was taken out of his account?
We bought animal supplies on August 17th of 2012, and there's been no activity since then.
When did you find out your father was missing?
August 19th, 2012, when I responded to an attempted break-in at Wild Wildlife.
How were you alerted to that break-in?
Around 6 a.m., the alarm at the office went off, and I live nearby, so I drove over to check it out. And when I got there, I saw the padlock on the gate had been cut off and the back gate had been pried open.
Were the police there?
They drove in right behind me.
Who else was there?
I saw the defendant and a guy I didn't even recognize coming out of the office. The guy was carrying a lock cutter and the defendant was carrying a lock box.
Were you familiar with that lockbox?
Yes, that's the lockbox where my dad kept his will. I kept it locked in the right-hand drawer of my desk.
When you saw the defendant, did she say anything to you?
No, she was just standing there smiling at me.
Did she say anything to anyone?
Yes, she told the police that she was the owner of Wild Wild Life, and if they had any questions for her, they should contact her attorney.
Were you aware that your father was missing at that point?
No, at that point, Karen was the only one claiming that dad was missing.
You told us that the lockbox the defendant carried away contained your father's will. Have you seen that will since?
I have not seen the will that dad kept in that box since he disappeared, but I have seen a will that the defendant produced after dad disappeared.
Your Honor, at this time,
I would object to the portion of the testimony where she claims that the will was produced by the defendant.
Your Honor, may I respond?
Yes.
The defendant did produce the will to the probate court, therefore I believe that statement was accurate.
I think it's an issue for semantics. I'll overrule it for now.
Your Honor, at this time, I'm citing opposing counsel and the witness to page 53 of the record. I'm marking that as Plaintiff's Exhibit 2. Cam, can you tell me what Exhibit 2 is?
Yes.
What is it?
That's the will that the defendant showed to the probate court.
Has this been changed or altered in any way?
No, it has not.
Your Honor, at this time, plaintiff offers Plaintiff's Exhibit 2 into evidence.
Any objection or voir dire, Mr. Drash?
No objection, Your Honor.
2 shall be admitted. You may publish.
Thank you, Your Honor. Looking at this will, how was your father's estate divided?
Karen was left with absolutely everything. My mother and I were left with nothing.
Who was named executor of this will?
This will provided that Karen would become the sole executor should my dad die or disappear.
What is the date on this will?
June 14th, 2012.
What was your father's relationship with the defendant like in the summer of 2012?
It was bad. Dad had just filed for a restraining order in June.
Had you heard your dad and the defendant fighting or arguing during that time?
I heard them arguing in Dad's office about 2 weeks before he disappeared.
What were they arguing about?
My dad had asked her for a divorce again.
How did the defendant respond?
She was furious and she stormed out of my dad's office.
What did your father do?
He came out of the office and he was visibly shaken. He was upset.
While your father was visibly shaken and upset, did he say anything?
Objection, Your Honor. Hearsay. I also believe that in motions in limine, your ruling was that once we will be advancing into this portion of testimony, we should first approach you to the constructive sidebar.
I think this, correct me if I'm wrong, we'll go outside the presence of the jury, Ms. Sims. This is in regards to Mr. Donaldson's statement to look at Ms. Baja if something were to happen to him, right?
Yes, Your Honor. I believe that motion was granted.
Well,
I may bring it up during cross-examination or during direct examination.
yes. Just so Mr. Darash knows, the testimony or the evidence that I said we should not bring up in front of the jury related to the temporary restraining order request.
Thank you, Your Honor.
Anyway, you're objecting to hearsay. Response to the hearsay objection then, Ms. Sims.
Your Honor, this falls under 803.2 excited utterance. Mr. Donaldson, when he made this statement, was visibly shaken and upset, and the record specifically states that he excitedly uttered, and therefore this does classify under that exception.
If I may briefly respond. What happened between allegedly happened between Karen Baja and Lou Donaldson was a fight between married couples. and married people do have arguments. Even more so, when Lou Donaldson left the office, he did not speak himself. He was asked the question, he had time to think about his answer, and then gave an explanation, which makes it less likely that it could be advanced as an excited utterance.
I disagree. As someone who has been married for 4 years, I can assure you that many marital fights can leave someone in a fairly excitable state. So I don't think that the fact that they're married is particularly persuasive. I am going to let the jury know that obviously it's their determination whether or not Ms. Baja was in fact the cause of Mr. Donaldson's death. However, I will admit this statement and overrule the objection. You can proceed, Ms. Sims.
While your dad was visibly shaken and upset, did he say anything?
Yes, he said if anything ever happens to me, be sure to have the police look into Karen because she will be the one responsible for my death.
No further questions, Your Honor.
Cross-examination, Mr. Josh.
Yes, Your Honor. Ms. Donaldson, you testified on direct examination about the alleged fight that you overheard between Karen Baja, and Lou Donaldson.
Yes.
And according to you, your father asked you to talk to the police if anything would have happened to him and to tell the police to look into Karen Baja.
Yes.
2 weeks later, you went to Wild Wildlife
Yes, like I do every day.
at 6 a.m.
Yes.
because the alarm went off.
Yes.
Karen Baja was there
Yes.
and the police were there.
Yes.
Yet, you did not tell the police anything about the fight that allegedly happened 2 weeks ago.
Well, at the time, I didn't know my dad was in trouble.
Is that a no to my question?
I did not.
You did not ask them to look into Karen Baja, did you?
Not at the time.
And on direct examination, you testified that Karen Baja was holding a lockbox.
Yes.
Well, you did not tell the police that the logbox, according to you, contained a will.
No, I did not.
Ms. Donaldson, let's talk about the content of the will. The will, according to you, divided the one that was in a logbox. According to you, divided the assets in 4 equal.
Objection, hearsay, Your Honor.
Objection. Your Honor, if I may briefly respond, I believe this testimony was elicited during the direct examination, so I don't understand the objection.
What was the question, Mr. Darash? I'm sorry, I missed it.
According to her knowledge, the allegedly previous will divided Dad's assets into 4 parts.
Your Honor, may I respond?
Sure.
We did not go into that during direct examination. We only asked this witness questions about the will produced by the defendant.
I recall hearing a question about a previous existing will because it came up in the fact that there had been a will in the lockbox. I'm going to allow this question. If the witness doesn't know, she doesn't know. Overruled.
Ms. Donaldson, the previous will, I will repeat my question. The previous will divided your dad's estate into 4 equal parts.
I don't know.
It is your testimony today that you don't know whether your dad's will, the previous will that you're talking about, divided the estate into 4 equal parts.
The previous will, I know that I had been left something, but I'm not positive exactly what.
Today, you're the only plaintiff in this lawsuit.
Yes. I'm representing my father's estate, yes.
You're not seeking 25% of your dad's estate, are you?
No,
Neither are you seeking 25% for wildlife,
no,
correct? In fact, you're seeking 100% of your dad's estate.
I'm seeking what Karen Baja took from my family.
Ms. Donaldson, is that a yes?
Yes,
I would like to talk about the last time that you've seen your father. It was a Friday, correct?
yes,
At the wildlife office?
yes.
He did not seem particularly sad on that day.
Nope, it was like any other Friday.
He did not complain about Karen Baja to you?
We had just
On that
discussed
Friday.
business.
In fact, when he was leaving, he suggested that the two of you will see each other on Monday.
Yes, he suggested that I would see him Sunday for supper or Monday at work, whatever I preferred.
Exactly. He did not say one way or the other whether he had plans for Saturday.
No, he did not mention Saturday.
You don't know whether your father had travel plans for Saturday.
I do not know that. He typically told me if he planned to travel, though.
Ms. Donaldson, did he tell you this Friday that he had travel plans for Saturday?
No, he did not.
Did he mention Saturday at all?
No, he did not.
Ms. Donaldson, your father, he was a pilot
Yes,
and he owned planes.
yes.
In fact, you don't know, till today, you don't know how many planes did he have.
He bought and sold them for business. I don't know exactly how many.
And on occasion, he used to fly without logging in a flight plan.
Yeah, I would always try and tell him to do that, but old habits die hard.
It is a yes. That
Yes.
on occasion he would fly.
Yes, on occasion.
Ms. Donaldson, you are aware that your dad's body was unfortunately never found.
Yes, we still haven't seen his body to this day.
Neither the remains of your dad's body were ever found at around wildlife property.
Not that we know of.
But what was found was his van.
Yes, his vehicle, yes.
Was parked in an airstrip.
Yes.
No further questions, Your Honor.
Can you redirect, Ms. Sims?
Yes, Your Honor. Did your father tell you that he was going to Costa Rica that weekend?
No, he did not mention that.
And why did you not tell the information about the defendant to the police?
Because at the time, I didn't know anything was wrong.
Who works at that police department?
Karen's brother.
Is this case still active?
Yes.
No further questions, Your Honor.
All right. Thank you, Ms. Donaldson. Plaintiff, call your next witness, please.
Your Honor, at this time, we would like to call an unavailable witness. We seek to play a portion of the Bob Exotic video, which we will mark as Plaintiff's Exhibit 2.
I think you already have an exhibit 2.
Excuse me, Exhibit 3, thank you.
And is there any objection to the plaintiff's exhibit 3?
No, Your Honor, this has been stipulated to pre-trial.
Okay. You may go ahead then.
See, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. It was illegal importing leopards and lions. Leopards was for her, Liquids for me. Lines was for her. Now, we never worked together before, and we never worked together since. But due to the severe illegality of the deal, we thought it best to be worked together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped, suddenly turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob?" That's me, Exotic Bob. She said, "Exotic Bob, where if you double cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica. She goes, your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that.
Your Honor, I'm so sorry about that. I have tried to disconnect that and didn't work, obviously, but it won't happen again. I can promise that.
That's fine. Apology accepted. Before we move on to the next witness, does the defense wish to admit any further portions of Exotic Bob's testimony?
No, Your Honor.
Next witness for the plaintiff.
Your Honor, before the plaintiff calls their next witness, may we be heard outside the presence of the jury?
You may.
Okay. We intend to bring up the temporary restraining order and admit it through Taylor Pride, the plaintiff's expert. And in response to that 404 argument, I'd like to argue that under 404B, this temporary restraining order is actually being used as evidence of motive and to show that Lou's disappearance was not an accident.
Okay. And what specifically, can you elaborate on motive for me, please?
Yes, Your Honor. Specifically, the restraining order mentions that the restraining order says that Karen Baja, defendant, has threatened to kill me. And then furthermore, it says, "I am seeking a divorce from Karen Baja." And it says, "I do not feel safe around Karen Baja." All of that shows motive because Mr. Donaldson was seeking a divorce from Karen, and any reasonable person would know that if someone's seeking a divorce, they're going to cut you out of their will, most likely. Therefore, if she knows that, then she has a motive to kill Mr. Donaldson and forge his will so she can take his entire $10 million estate.
Okay. And this would be Mr. Donaldson's perception of this?
Yes, Your Honor. So state of mind as well, if there's any hearsay.
Okay, Ms. Stoig.
Your Honor, if I may respond, Mr. Donaldson's state of mind is not relevant in today's case. And his opinion about the temporary restraining order is also not relevant. This witness, this expert witness, will not be able to lay the requisite foundation that this temporary restraining order served as motive. And it's our contention that opposing counsel will not be able to lay that foundation at all in today's case.
Your Honor, may I respond?
Sure.
The temporary restraining order was actually considered by Mr. Pride in coming to his opinion that the will the defendant produced was a forgery. Therefore, under 703, I'm allowed to elicit this kind of information on whatever he considered to form his opinion, so long as it helps the jury in understanding the opinion.
Well, I don't know if 703 is quite that broad, Ms. Hall. I think that, you know, is it Mr. Pride?
Yes, Your Honor, it's Mr. Pride.
I think that in order for that evidence to be shown to the jury, the data would have to, in this case, the temporary restraining order, the probative value would have to outweigh any prejudicial effect. It's my understanding that Mr. Pride analyzed the signature on the restraining order in analyzing signatures. Is that correct?
Yes, Your Honor, but he also led a full-fledged investigation into the disappearance of Mr. Donaldson.
Your Honor, if I may be heard on that.
Okay.
It's our contention that this witness will not be able to be admitted as an expert investigator in today's case, and therefore the temporary restraining order in its entirety is not something he relied upon. We have no problem if the plaintiff wants to talk about the signature itself and the handwriting of it, if they want to show a redacted version or just blow up the signature. Of course, we have no problem with that under 703. But under 703, to know that there is a temporary restraining order filed in today's case, even though it was denied, has enormous prejudicial concerns and would be unfair for the jury to hear that.
So I think this is a really tough call. I'll be candid with the parties. I can see the probative value, but I do feel like the prejudicial effect is very high, particularly because obviously the defense is unable to examine Mr. Donaldson about the basis of this. We have sort of a flat document that looks very suspicious, I suppose, if you will, without the ability to really go any further into it. So I'm concerned about the prejudicial effect. What the court will do, I'm going to admit the exhibit, but I'm going to do so with a strict limiting instruction. And that's that they can only use it to see for purposes of Mr. Donaldson's state of mind at that time, and can use it for no other purpose. So they cannot use, there can be no argument that the temporary restraining order proves that Ms. Baja intended harm to Mr. Donaldson. It really cannot have any argument that relates to Ms. Baja as it relates to the restraining order. So, not that, and I'm trying to remember what the three things are specifically in the restraining order, but I know it's something about fear of death. And what are the other 2 points in it, please, Ms. Hall?
It's that Karen Baja, the defendant, has threatened to kill me. I'm seeking a divorce from Karen Baja, and I do not feel safe around Karen Baja.
Okay, so again, you can utilize it for Mr. Donaldson's perception. And if it's that he wanted a divorce or that he had fear, that's fine. But anything to do with Ms. Baja's state of mind or her actions, I'm not going to allow any argument on that. So it's solely being admitted for the limited purpose of showing Mr. Donaldson's state of mind. And so I'll instruct the jury as such and trust the plaintiff to cater their arguments appropriately.
Yes, Your Honor. Thank you.
I'm sorry, Ms. Stoic, what's that? I didn't hear you.
I just said I understand, Your Honor.
Okay. All right. Any other clarification? I've made that confusing, I realize, for the parties, but where we're at.
No, Your Honor, I think I understand. So we can admit the restraining order through, or we can attempt to admit the temporary restraining order.
Yes, that's fine. Just again, I will instruct the jury that it's only to illustrate Mr. Donaldson's state of mind at that time.
Yes, Your Honor.
Okay. And you can use the signature, though, since that was not objected to for forensic document analysis. That's fine, too.
Yes, Your Honor. Okay.
Thank you.
With that, the plaintiff calls Taylor Pride. Could you please introduce yourself for us?
My name is Taylor Pride.
How are you involved in this case, Mr. Pride?
I was hired by Kim Donaldson to analyze her father's Lou's alleged signature on the will presented by the defendant.
Before we get into your analysis of that will, I'd like to talk a little bit about your background. Where are you from?
I live in Statesville.
What do you do for a living?
I work as a private investigator at the firm I started, Pride Investigations Incorporated.
Tell us how you became a private investigator.
So I started my career with the Pioneer Police Department in 1998 as patrol officer, but was quickly promoted to detective in 2000. I left the police department in 2016 and started Pride Investigations.
What kind of cases have you investigated?
Oh, I've investigated every type of case from economic crime to murder.
Before we get into your investigation and opinion, let's talk a little bit more about your background. Have you ever investigated forgeries?
Yes, while I was assigned to the economic crime unit at PPD, I spent a lot of time investigating forgeries.
Have you received any education in analyzing signatures?
Yes, I attended an extensive 2-week seminar from the American Association of Handwriting Analysts, in which I was trained to analyze and compare handwriting.
Mr. Pride, what is the American Association of Handwriting Analysts?
It's the premier organization when it comes to graphology and document examination.
Are you certified in handwriting analysis?
Yes, I have been certified with the American Board of Forensic Document Examiners since 2002.
Does your current job as an investigator ever involve any kind of handwriting analysis?
Yes, I continue to practice in the field.
Have you ever testified as an expert in the area of handwriting analysis and document examination?
Yes, I've testified as a handwriting analysis expert 15 times since 2002 in civil cases for both the plaintiff and the defense, and also criminal cases.
Your Honor, at this time, we tender Mr. Pride as an expert in handwriting analysis and as an expert in the investigation of economic and financial crimes.
Mr. Did you want to voir dire or have any objection to that tender?
Yes, Your Honor. May I have voir dire? Mr. Pride, you've been an expert in handwriting analysis before.
I have.
Never in investigations.
Well, I did investigate some certain situations when I was at the Economic Crime Unit.
Okay, but my question is, you've never been certified as an expert in investigations in court.
Is there a specific certification you're referring to?
You've never been admitted as an expert in any kind of investigations in court.
Sure, yes. I've been an expert for handwriting analysis specifically, but never as an investigator.
You've never received any kind of certifications for investigating.
My certification is with the American Board of Forensic Document Examiners, but I don't have anything else.
So I'm correct that you're not a certified fraud examiner.
Again, American Board of Forensic Document Examiners is my sole certification.
Your Honor, I have no objection to this expert being admitted as a handwriting expert, but I do have a problem with him being admitted as an investigation of financial crimes expert. There's been no foundation laid to establish that. This witness has just testified that they're a private investigator. They have no certifications in economic investigations. They've never been admitted as an expert before in economic investigations, and it would be improper for them to be admitted now as a private investigator.
Okay, response to that, Ms. Hall.
Your Honor, this witness has the knowledge, experience, and training to be qualified as an expert in the investigation of financial and economic crimes. He's been an investigator for over 20 years. He's investigated every type of case from economic crime to murder. He knows a lot more than the average person, and he's got experience in this field to testify as an expert in that area.
You know, this is another interesting area of the law that I think is changing quite a bit, as the parties probably know. At one time, you know, police or private investigators, but since Mr. Pride has experience as a police officer, really didn't testify as experts. And now there is somewhat of a shift towards expert testimony when it comes to law enforcement or investigations. Typically, though, we're seeing that kind of expert testimony on really specific areas of investigations. For example, like roadside, you know, sobriety maneuvers when we're looking for horizontal gaze nystagmus, or perhaps forensic interview techniques. And the reason I state this is because typically a standard investigation, I don't think by itself is going to fall within expert purview. Is there something specifically, Ms. Hall, that you think is going to require expert testimony? And I'd say this because I imagine most of his investigation could probably be admitted as lay testimony.
Yes, Your Honor. We talk a little bit, or we plan to talk a little bit about his investigation outside of the handwriting analysis, because some of that actually contributed to his opinion that the will was forged.
Well, okay.
Your Honor, if I may.
Sure.
Ms. Baja is not being charged with an economic crime in today's case. This expert examined a will. For him to be proffered as an economics crimes investigator and testify about an investigation that he wasn't even a part of is improper, especially when there's no foundation laid that he has any kind of special certifications or knowledge beyond that of just an ordinary police officer or private investigator.
Your Honor, may I respond?
Let me ask you a question first. The first area of expertise that was not objected to, is that what was the phrasing you used for that, Ms. Hall?
In handwriting analysis.
Well, if you're asking, correct me if I'm wrong, but in examining courtroom documents, they're not typically, an expert like this is not just examining handwriting. Am I incorrect?
No, Your Honor, you're not incorrect. I mean, he's done a full-fledged investigation, and there are circumstances outside of the handwriting analysis that actually factor into his opinion that this will was indeed forged.
Candidly, I think all of us are somewhat arguing, different sides of the same sword here, because I think if Mr. Pride is going to be testifying about forensic document examination that can go outside of just a handwriting analysis, I understand being familiar with this type of certification, that they look at more than just handwriting. What I'm concerned about, and so I'm going to, if in analyzing the document, the will itself, for credibility, there is additional analysis outside of just the handwriting, I will allow that based on the witness's experience. My concern is I don't want this to be a door to try to get into hearsay that is not really relevant to the issue of the legitimacy of the will, right? Sometimes when we utilize an expert tender that just says sort of examine, investigations generally, that, can be sort of a blanket statement to just try to get in as much evidence that might otherwise be inadmissible. So I will recognize Mr. Pride as an expert in the area of handwriting analysis and will examinations. I'm going to limit it to that. And so if based on the statement that he's investigated hundreds of wills for fraud, I'm fine with that. But I don't want a blanket, he's an expert in investigations. I think that's too broad. And so I'm going to limit it again to handwriting analysis, and will examination. If you think, Ms. Doig, that we're getting outside of that and again, trying to utilize this, 703 inappropriately, you can object. So that will be the court's ruling. We're good for handwriting and any evidence that relates to fraudulent wills.
Understood, Your Honor.
Great, thanks.
Mr. Pride, have you reached an opinion about whether Mr. Donaldson's signature on this last will and testament produced by the defendant is a forgery?
Yes, I have.
Before you tell us what that opinion is, tell us what you reviewed to come to that opinion.
So I reviewed all the documents from Chris Renard, the insurance investigator, the signature on what the defendant claims to be Mr. Donaldson's last will and testament, and Mr. Donaldson's signature on his driver's license, a petition for a restraining order, and a note he wrote to his daughter in May of 2012.
Are these documents and signatures the same types of things that other handwriting experts in your field would rely on in forming an opinion?
Yes.
Is your opinion based on sufficient facts and data?
Yes.
Is your opinion to a reasonable degree of professional certainty?
Yes.
Let's talk about your analysis of the signature on the will. What steps are involved in analyzing and comparing handwriting samples?
Well, there are 3 steps. First, obtaining a known sample of the author. Second, analyzing those samples that are known. And third, comparing those known samples to the handwriting in question.
Is that what you did in this case?
Yes.
Let's take that first step in your analysis. What were the samples of Mr. Donaldson's known handwriting that you obtained?
Those would be the signatures on his driver's license, petition for restraining order, and the note he wrote to his daughter that I previously mentioned.
Citing the court and opposing counsel to page 40 of the record. Mr. Pride, will you please look at page 40 of the record for me?
Yes.
All right, I'm going to mark this as Plaintiff's Exhibit 5. Do you recognize this?
Yes.
What is it?
This is Plaintiff's Exhibit is this is a signature comparison showing the known samples of Lou Donaldson from the life insurance policy and from his driver's license, as well as the signature in question from the last will and testament produced by the defendant.
Has this document been changed or altered in any way?
No.
Your Honor, plaintiff offers Plaintiff's Exhibit 5 and the evidence constructively redacting all but the signature comparison chart.
Any objection or voir dire to that, Mr.
No, Your Honor. I just want to clarify for the record, is this number 5 or number 4?
I have it as 4 as well, Ms. Hall.
Well, we can make it Plaintiff's Exhibit number 4.
Do we have an Exhibit 4?
No, Your Honor, we don't have an Exhibit 4 yet.
Okay. So this is signature comparison redacted.
Right, and then so we'll go ahead and put it in as 4.
Great.
Sorry.
No, that's fine. And you can publish. Go ahead.
Now, Mr. Donaldson, you said the second step is to analyze the known samples. What are handwriting analysts looking for when analyzing known samples?
An analyst looks for handwriting characteristics such as shapes, curves, angles, stroke direction, legibility, letter height, weight, capitalization, and embellishment.
Does an analyst focus only on individual letters?
No, a good analyst will look not only at the individual letters, but focus on how certain letters connect and identify those connection patterns.
You told us that the third step in the case, or the third step in your analysis, was to take the known signatures and compare them to the signature in question. Did you do that in this case?
Yes.
Were there any differences between Mr. Donaldson's known signature and the signature on the purported will?
Yes.
Were there any differences in the individual letters?
Yes.
What were those differences?
Well, first, the D in Donaldson on the known samples is a single movement in which the pen is lifted off the paper for just a second.
Is that the same on the will?
No, the D in Donaldson on the will is clearly 2 distinct pen strokes.
Can you identify that on Plaintiff's Exhibit 4?
Yes. So, as to your first question, you'll see it only briefly lifts up on the first known signature, but when we're looking at the signature in question on the last will and testament, you can see it lifts up in 2 different places.
Okay. What was the next difference?
The writer of the signature on the will writes every letter, including the lazy second O in Donaldson, individually.
Is that lazy O on any of Mr. Donaldson's known signatures?
No, the lazy O is not clearly written out on Mr. Donaldson's known signatures.
Were there any other differences that you noted, Mr. Pride?
Yes. In fact, the biggest mistake the writer of the signature on the will produced by the defendant made was lifting the pen much more frequently than Mr. Donaldson did.
Are there any other factors a forensic document examiner is looking for when comparing known samples to the handwriting in question?
Analysts are looking for retouching, hesitation, or other signs of unnatural writing.
Now, Mr. Pride, were there other circumstances surrounding the will that you considered in forming your opinion?
Yes, I also considered the language in the will.
What language did you consider?
The will provided that the defendant would be the sole executor of his estate should he die or disappear.
Now, Mr. Pride, have you seen that kind of language before in another will?
As someone who has investigated hundreds of wills, I have never once seen the term disappear in a will before. In my experience, people don't plan a will in case they possibly disappear.
Objection, Your Honor. Speculation.
Response to the speculation objection?
Your Honor, this expert he even qualified it by saying, in my experience. This is not speculation. He is going straight to his personal knowledge and drawing his answer from that.
I agree. Overruled.
Now, Mr. Pride, Other than the language in the will, were there any other differences surrounding the will that you considered?
Yes, the petition for a restraining order that Mr. Donaldson filed against the defendant.
Citing the court and opposing counsel to page 55 of the electronic record, alternatively known as Bates 16. Now, Mr. Pride, will you please look at page 55 of the record?
Yes.
This is what I'm going to mark as Exhibit 5. Do you recognize Exhibit 5?
Yes.
What is Exhibit 5?
This is the petition for a restraining order that Mr. Donaldson attempted to get on June 12th, 2012.
And has this document been changed or altered in any way?
No.
Your Honor, plaintiff offers plaintiff's Exhibit 5 into evidence.
No objection based on your previous ruling.
Noting the previous objection, 5 shall be admitted and you may publish.
Now, was this the exhibit that you considered in forming your opinion?
Yes.
And what's the date on that restraining order?
That would be June 12th, 2012.
And the date on the will was June 14th, 2012, wasn't it?
Yes.
All right. Mr. Pride, how many days in between June 12th and June 14th? How many days are in between June 12th and June 14th? I'm sorry about that.
2 days.
All right. Mr. Pride, what is your opinion about whether this will produced by the defendant is a forgery?
It is my opinion that the signature on the will was not written by Mr. Donaldson, and it is a forgery.
No further questions, Your Honor.
All right. Cross-examination, Ms. Twigg.
Oh, I'm sorry, Your Honor. One moment. Just getting used to these Zoom cameras.
No problem.
May I proceed, Your Honor?
Yes, go ahead.
Mr. Pride, you were hired by the plaintiff to examine if this will was a forgery.
Yes.
The plaintiff paid you to write your report,
Yes.
and you were here for your client's testimony here in court today.
Yes.
You heard your client say that there was a previous will.
Yes.
You heard her say that she was supposed to be a recipient of some of the estate in that previous will.
Without examining the will, I wouldn't want to speak to it.
I'm just asking what you heard your client say.
Yes, she did say that.
Mr. Pride, you've never heard that before.
I'm sorry, I don't follow.
Your client never even told you that a previous will existed.
Not in our prior conversation. She did testify to it today, though.
And that's right. The first time you're even hearing about a previous will is today in court.
Yes, but I think I assumed one existed.
All right, well, I don't want to get into what you're assuming. I want to talk about what you knew. You didn't know anything about a previous will.
We had not directly discussed it.
Now, you know that the will that's in question today, Ms. Baja presented that will back in 2012.
Yes.
Mr. Pride, you weren't hired in 2012.
No, at that time I was still working for PPD.
Your client didn't say that this will was fraudulent to you until 2017, right?
Correct.
And just to be clear, that was just a month before Ms. Baja was to receive the inheritance of that will.
Yes.
Mr. Pride, as an expert, you've looked at hundreds of wills, like you said.
Yes.
But you know, it's not uncommon for someone to leave their estate to their spouse.
Correct.
Miss Baja, she was Lou Donaldson's spouse.
Yes.
They were married for 11 years.
Yes.
Not only that, but they were business partners.
Correct as well.
They worked caring for wild animals together.
Yes.
Now, I want to talk to you about the signatures in today's case. You mentioned on direct that the first step in evaluating a signature is taking known samples of the author, right?
Yes.
And you told us the known samples that you gathered were ones from a DMV and a court document, right?
Yes.
As well as a letter that Mr. Donaldson wrote to your client.
Yes.
And letters like those are important. Things like grocery list journals, they're good to see someone's handwriting, right?
Yes.
Now, Mr. Pride, I have your report. You didn't attach that letter to your report, did you?
We used Mr. Renard's analysis for our report.
So I'm correct. You didn't attach that letter in this report.
Correct.
You didn't bring it to court here today.
No, I did not.
So the jury, they can't actually compare the handwriting in that letter to Mr. Donaldson's handwriting.
Well, we had 2 viable samples already.
Okay, but my question is the jury. They can't compare the handwriting on the will to the handwriting in that letter because you didn't bring it here.
Correct. But I'm the expert, not the jury.
Okay, Mr. Pride. Let's dive specifically into the signatures. Your Honor, I have compiled what's already been moved into evidence. I believe it's, if I just check my record, Exhibits 4 and Exhibits 5 compiled into one document, just the signatures. May I display using screen share?
Sure.
So, Mr. Pride, that first signature, that's Mr. Donaldson's signature on Summit Life Insurance paperwork, right?
Yes.
That second one's his signature on his driver's license?
Yes.
And that third one, that's his signature on a court document?
Yes.
Mr. Pride, we can agree. These are his known signatures.
Yes.
We're not in dispute today.
No.
I want to talk a little bit about these signatures, starting with the L's on those signatures. Mr. Pride, you can agree with me. The L's in each of these signatures look a little different.
There's slight variation.
Now let's look at those third O's before the N. Sometimes the O is more full than other times, right?
Yes, the third example does appear to be a little more fleshed out than the previous 2, but it seems to be the same motion. But yes, it is slightly different.
And now I'd like to direct your attention to the tail of the N. In each of these signatures, the direction the tail moves is a little different.
Yes, the first is different.
Thank you, Mr. Jones. Now, Mr. Pride, that's because signatures change.
Yes.
A person's signature can change because of age,
Yes.
because of health at the time of signing,
Yes.
the type of pen that a person uses to sign their name
Certainly.
can change depending on how slow a person writes
Yes.
or how quickly someone signs their name.
Correct as well.
In fact, Mr. Pride, no one's signature is ever exactly the same.
No, certainly not.
Nothing further.
Any redirect, Ms. Hall?
Yes, Your Honor. Mr. Pride, how long have you been certified with the American Board of Forensic Document Examiners?
I was certified in 2002.
Now, in reaching your opinion that the will the defendant produced was a forgery, did you rely on your almost 20 years of experience and training as a forensic document examiner to reach that conclusion?
Yes.
All right. No further questions, Your Honor.
Great. Thank you, Mr. Pride.
May this witness be excused?
Yes.
Good deal. He's excused.
Any additional witnesses for the plaintiff?
Yes, Your Honor. The plaintiff calls Carl Bannister by deposition.
Okay.
Stipulation 4 on page 9 of the record provides that Mr. Bannister is unavailable pursuant to 804A. For the court and counsel's convenience, if no objection, plaintiff will read the entirety of the first page of Mr. Bannister's deposition, which is page 33 of the record, to the third question and answer on the second page, which is page 34 of the record, continuing to, and then on page 35 beginning with the second question on that page until the question reading no further questions.
Ms. Doig, any objection to that procedure? And I should also say, I will give you the opportunity as a cross-examination to read anything additional that you wanted to as well.
Yes, Your Honor. If I can just clarify with Ms. Hall if this is what she showed me pre-trial or if there's been any additions.
It's what I showed you pre-trial.
No objection, Your Honor.
Great. Go right ahead, Ms. Hall.
May I read the questions while Ms. Sims reads the answers?
Yes, that's fine.
And would Your Honor like for me to explain to the jury what a deposition is, or would the court prefer to do that?
I can do it, but thank you.
All right, Ms. Sims. Hello, Deputy Bannister. Would you please state your name and spell it for the record?
Deputy Carl Bannister, CarlBannistr.
What do you do for a living?
I'm a deputy sheriff for Pioneer County, Statesville.
How long have you worked as a deputy sheriff?
I was first hired out of the academy in May of 2005 by Pioneer County. I've worked there for over 15 years now.
How are you involved in this case?
Well, I'm not involved in the case, but I guess you could say I'm here because my sister is Karen Baja.
Are you older or younger than your sister?
She's my little sister, as I am older by a couple years.
Do you have a close relationship with your sister?
We're family, so there are ups and downs to any family relationship. However, I would say that we are pretty close.
Okay. Let me ask you about the night, early morning hours of August 18th, 2012. Do you remember that pre-dawn time?
Yes, I do.
How do you remember it?
I was on duty that night, graveyard shift. So from 12 a.m. to 8 a.m.
What do you remember about that time?
Well, it was normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
When was that?
It was close to 3 a.m. She had gone out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
Did you go to pick her up?
Yes, I did.
Did you use your patrol car?
Yes, she was actually in my patrol area.
When did you pick her up?
Well, I was just finishing the paperwork on a DUI arrest, so it took me just a few minutes. I wrapped up what I was doing and met up with her around 3:20 a.m. or so.
Now, are you aware that the Pioneer Sheriff's County office keeps tracking records for all vehicles?
Sure. It is a good way to know where each deputy is located and the jurisdiction during a shift.
Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m. as it was showing it was near the grocery store close to Miss Baja's home during that time?
Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day.
Let me turn your attention to approximately a week later, August 24th, 2012. Did you see your sister, Miss Baja, that day?
Yes, I drove her to a small airport so that she could pick up Lou's van. It was about 40 miles away, and I didn't want her to have to pay for a ride, so I took her. The sheriff's office released his van to her right away. It is my understanding that they didn't need to examine it or anything. So she grabbed it, and we caravaned back to Pioneer.
No further questions.
Does defense have any cross-examination?
No, Your Honor. Plaintiff's counsel already covered it.
Okay, great. Any additional witnesses for the plaintiff?
No, Your Honor. The plaintiff rests.
Okay. I assume that defense may have a motion, but I would like to take a recess beforehand. It is 5:43 Colorado time. Let's return like 5:50 50, 51, 52. We'll try to get around like 9, 10 minutes. If everybody's back, we can get started, but if not, we'll give it a full 10 minutes. So I will see you shortly. Thank you.
Yes, Your Honor.
Thank you.
Guess we're the first ones back. I think you're on mute.
Yeah, I was, sorry.
No worries. I understood the message. It's getting late. I feel the same way.
Yeah, it's a good case. It's
Yeah,
really interesting.
for
You
sure.
guys having a lot of fun with it?
Yes, definitely. It's great that they're able to do this virtually too, because last semester everything was basically canceled because they weren't able to prepare for things. But now that COVID's been around for a while and Zoom's been around for a while, it's nice that they can still do this kind of stuff.
We're figuring things out as we go, right?
Yeah.
I know. I work for the U.S. Space Force, and so there's a lot of stuff that's
Oh, wow.
done at, in classified areas. And at first people thought, how are we going to get anything done? But
Yeah.
now as things go on, it's like, yeah, we figured it all out.
Yeah.
So I don't know if I'm allowed to talk to you guys.
Oh.
Maybe I should put my mute button on. Well, good luck to you guys all.
Thank you.
Doing great.
You guys have really inspired me to work on my bookshelf game. Looks
Yeah.
so good.
Yeah, it's a lot of
Olivia,
books on that bookshelf.
We had someone yesterday who had a similar setup, but they had automatic lights. And so like they're motion censored. And when you're sitting down, so she's doing her pre-trial and the lights were flickering, like they would suddenly go off and it would be the dark. And you're like, oh, that's probably things you don't even think about. I wouldn't even think about that going into this.
Yeah, it's definitely a learning curve with everything being online,
For sure.
I have to admit, I thought the bookcases were fake.
I thought that too.
Background.
I thought it was a virtual background when we met in pre-trial, and I was like, wow, it looks pretty realistic.
They are fake though, correct? It's a background. They're real?
Oh yeah, these are real books. These are
Oh
real.
my God, that's awesome.
Everything.
If you need any case law during the trial, you can just go back and grab something.
Grab a book and start reading.
Yep.
I'm sorry I'm late. Okay. Do we have everybody that we need? It looks like it. Excellent. All right. Are there any motions from the defense before we begin with their case?
Yes, Your Honor. Defense moves for judgment as a matter of law pursuant to Rule 50, even viewing the evidence in the light most favorable to the plaintiff, non-moving party. They failed to meet the burden. They did not establish that it was intentional or reckless conduct of Karen Baja that resulted in Lou Donaldson's death. They did not produce any evidence of the body or where it is, no autopsy results, no DNA tests. And as we all heard, in fact, plaintiff just read the whole deposition of Carl Bannister, which proves that defendant has an alibi. And for these reasons, defense asks for the judgment as a matter of law.
Okay. Any response?
Yes, Your Honor. As Your Honor knows, when considering the defendant's motion, the evidence and all inferences from that evidence must be viewed in the light most favorable to the non-moving party, the plaintiff in this case. Your Honor, we've presented evidence that Lou Donaldson has been declared legally dead, that the defendant threatened him, that after Mr. Donaldson told his only child to investigate the defendant if anything ever happened to him, he disappeared. He never withdrew any money following that, and his last will and testament was clearly a forgery. Your Honor, we've produced evidence of motive. Therefore, and as Your Honor knows, the law makes no distinction between direct and the effect of direct and circumstantial evidence. And there is more than sufficient evidence and inferences that can be drawn from that evidence for the plaintiff's claim to be presented to a jury.
Okay. I'm going to deny the motion. I think the case should proceed forward, and I look to the defense to call your first witness, please.
At this time, defense calls Karen Baja to the stand. Good evening. Please introduce yourself to the jury.
My name is Karen Baja.
Ms. Baja, where do you live?
I live right here in Statesville.
And do you work?
I don't really call it work because I love what I do, but yes, I work at Wild Wildlife, taking care of all the animals. They're like my big furry family.
What kind of animals you talking about?
Tigers, lions, leopards, big cats like that.
Ms. Baja, how long have you been taking care of your cats?
Since I met my sweet hubby, Lou.
And how did the two of you met?
It was fate, truly. I was hitchhiking one day and he pulled over to the side of the road and asked me if I wanted a ride. I knew right then and there that it was love at first sight. The rest is history.
Ms. Baja, when did the two of you get married?
I'll never forget the day. May 29th, 2001, almost 20 years ago. It was a dream come true until this whole nightmare began.
What nightmare? What nightmare are you talking about?
One day, Lou just disappeared. It's been awful. I miss him so much and would do anything to be able to be back together, taking care of our little love muffins again, but it's just been such a nightmare.
Ms. Baja, obviously you're aware that today you're here as a defendant. Did you kill Lou Donaldson?
Absolutely not.
Did you ever threaten him?
No.
Did you put his body into a meat grinder and then feed him to the cats?
That's crazy. Of course not. Cam came up with that idea and it's complete fiction.
Ms. Baja, were you even charged criminally?
No, of course not.
As far as you know, what did happen to your husband?
I wish I knew, truly. That's part of the nightmare and why this has all been so hard. One day he was here and the next he was gone.
Ms. Baja, how did you react to your husband's disappearance?
I was sad. I was so sad, devastated. He was always secretive about his coming and goings, and I tried not to be a nagging wife, always demanding answers. So I often didn't really know where he was going and when.
What did you do?
I told the police.
And where were you the night your husband, Lou Donaldson, went missing?
I was at Wild Wild Life. I was taking care of the little cubs that were just born. Unfortunately, their mother had rejected them. So I had to make sure they were safe and sound. I was back at home taking care of them.
And how do you keep them safe and fed?
I take care of them like a mama does her own babies. I give those love muffins lots of love and always make sure to give them lots of milk as well.
How do you remember specifically that on that night you were taking care of your cubs when Lou went missing?
Unfortunately, we ran out of milk in the middle of the night. And if any of you know what it's like having babies wake up in the middle of the night, you don't mess around. So at like 3 a.m, I could hear them crying and realize they needed more milk, and I had to run out. I guess that's the biggest difference between human babies and tiger babies. Can't leave human babies at home. But yeah, I ran out to the store, had to get more milk.
Ms. Baja, where was your husband during this?
To be honest, I wasn't quite sure. We hadn't really been getting along too well lately.
You said you haven't been getting along too well lately. What do you mean by that?
I mean, Lou was up to his ways.
Ms. Baja, what ways are you talking about?
I mean, if you want me to come right out and say it, Lou was having an affair. I knew it. He knew I knew it. I tried to turn a blind eye to it, but I knew. I mean, I met Lou when he was married, so shouldn't have surprised me, but I knew he was having an affair.
Do you know with who?
I never wanted to know her name. Would you want to know that? I tried to ignore it, but I couldn't.
Where did she live?
Costa Rica. It's beautiful there. Have you ever been?
Ms. Baja, I've been to many countries, but Costa Rica, unfortunately, is not one of them. But let's get back to the examination. How would your husband even get to Costa Rica?
You kidding me? The man had more money than God. He owned planes and kept them everywhere.
How many planes did your husband own?
Damned if I know.
Do you know what kind of planes?
A tiny little puddle jumper. I worried my little heart out every time he flew around in one of those things.
Where did he keep his planes at?
All over the place, but I know for sure he used to go back and forth to and from Costa Rica.
And where would he fly to?
All over the place. I mean, I knew that. I don't know. He would fly all over the place, but I know for sure to and from Costa Rica.
Ms. Baja, where was your husband's van found?
Surprise, surprise, at an airstrip.
Ms. Baja, let's talk about one of your stepson's accusations. One of them is that you killed your husband, and another one is that, they claim that you forged the will. Did you forge a will?
I wouldn't even know how to do that. Of course I didn't do that.
And who did your husband choose to leave his estate to?
Me. I was the one always taking care of Wild Wild Life with Lou baby. He took care of me just like we took care of those fur babies. But I'd give all of that money back if I could have one more day with him, I'll tell you.
Ms. Baja, what did happen to Wild Wild Life after your husband went missing?
Honestly, it's been thriving. I'm doing my best to keep everything ongoing, even though it's been really hard doing it without my sweet hubby.
Thank you, Ms. Baja. Your Honor, no further questions.
Cross-examination?
Your Honor, before I begin my cross-examination, may I be heard outside of the presence of the jury?
Sure.
Your Honor, I'm aware that the restraining order has been admitted for a limited purpose so far. So I just wanted to clarify before I begin my cross if this includes that it is subject to cross-examination for the purpose of acknowledging its existence and the contents that are found within it.
Well, I don't have any problem with the existence of it. What specifically are you looking at for content?
Solely the 3 statements that are contained within it.
I'll give you a little bit of leeway.
Yes, Your Honor.
Your Honor, if I may be heard of that.
You know, there's still going to be a limiting instruction. I've made my ruling. Let's go forward. Thank you.
Yes, Your Honor.
Ms. Baja, you claim the night your husband disappeared, you were at the grocery store.
For part of it, I was, yes.
That's right, at 3 o'clock in the morning.
Around then, yeah.
Around then, you were there at 3 o'clock in the morning, correct?
Yeah, I mean, I wasn't, yeah.
That night, you just so happened to leave your cell phone back home.
I did.
And that night, your car just so happened to break down.
It did.
And that night, your husband just so happened to disappear.
He did. I mean, it didn't just so happen. It happened.
When your car broke down, you didn't call your husband.
No, I called my brother. He's a deputy and he was patrolling around the area, so he came and picked me up.
And you got your brother to bring you to Wild's Wildlife.
He took me back home, yeah.
He brought you to Wild's Wildlife, correct?
Well, he brought me back to my kitties in my cat nursery back at home.
The cats are located at Wild's Wildlife, right, Miss Baja?
Yeah, there are cats located there, but the kitty nursery is in my house.
Miss Baja, you have a meat grinder at Wild's Wildlife, don't you?
I sure do. It's how I feed my kitties.
And that meat grinder, it is not small.
No.
The meat grinder is massive.
It's large.
It's so big that it takes 2 people to use it, like you've said before.
That is correct.
That meat grinder, big enough to grind up a cow.
I guess, yeah.
Big enough to dispose of a human body.
Yeah, you asked me that. Someone asked me that during my deposition. I guess so. I wouldn't know from personal experience, but I guess.
Sure. Before Mr. Donaldson disappeared, you were having marital problems.
Yeah, we were working through some things.
In fact, Mr. Donaldson asked you for a divorce.
He did.
Mr. Donaldson filed a restraining order against you.
He did, and I know that looks bad. It got denied. Didn't even make it to court, but he did. Like I said, we were definitely working through some things.
Like you just said, and like you've testified before, you admit it looks bad.
Yeah, it don't look great.
Ms. Baja, you petitioned to have Lou Donaldson declared legally dead in August 2017, right?
Yes, I did.
And you were granted your husband's entire estate by that will you brought forward.
Yes, I was.
Your Honor, may I share my screen to show Plaintiff's Exhibit 2, which has already been admitted?
You may.
Looking at this will, you were appointed the sole executor of Mr. Donaldson's estate.
I was.
Looking at this will left you all of Mr. Donaldson's real and personal property.
It did.
With Mr. Donaldson dead, you stood to receive $5 million from this estate.
Yeah, I'd give it all back. But yeah, according to the will.
And with Mr. Donaldson dead, you stood to receive $5 million from the insurance company.
Yeah, again, I mean, it breaks my heart to even hear over and over that you think my hubby's definitely dead. But yeah, according to the will. I'm sorry. You asked about the life insurance. According to the life insurance, that's correct as well.
So, Ms. Baja, with your husband dead, you stood to make approximately $10 million.
Yeah.
Ms. Baja, this will is dated June 14th, 2012, right?
That's what it says right there. Yeah.
And you want this jury to believe that just 2 days after Mr. Donaldson filed a restraining order, he wrote this will?
I want this jury to believe the truth. That's the truth.
No further questions, Your Honor.
Any redirect?
Your Honor, no redirect.
All right. Thank you, Ms. Baja. Additional witnesses for the defense.
Yes, Your Honor. The defense calls Chris Renner to the stand. May I proceed, Your Honor?
Yes.
Ms. Renner, please introduce yourself to the members of the jury.
Hi, my name is Chris Renard. That's Renard.
What do you do for a living, Ms. Renner?
Sorry, can you repeat that?
I'm sorry. I just asked what you do for a living.
Yes, I'm a forensic document examiner.
What exactly is a forensic document examiner?
I look at documents for legal aspects, like whether the document is genuine or forged.
How long have you been a forensic document examiner?
23 years now. I got certified with the Board of Forensic Document Examiners.
Have you ever testified as an expert in forensic document examination before?
Yeah, 25 times before.
What do you do? Where do you work, I mean?
I work for Summit Life Insurance.
How long have you worked there?
20 years.
Your Honor, at this time, I offer Chris Renard as an expert in forensic document examination and handwriting analysis.
Any objection or voir dire, Ms. Hall?
No, Your Honor.
And that was in, what was the field again, Ms. Doig?
Forensic document examination and handwriting analysis.
Okay.
I assume the expert is tendered, Your Honor?
Yes, I'm sorry. She's recognized as such.
Ms. Renard, I'd like to talk about how exactly you got involved in this case. Can you tell us how?
Yeah, so Lou Donaldson has a life insurance policy with the company I work for. And when Ms. Baja submitted the life insurance claim, Summit asked me to look into this.
Why would you be looking into this claim?
Well, they wanted to have me determine whether or not we should pay out this claim. Yeah.
Why exactly does an insurance company have to look into a claim like this?
Well, we're a business, first and foremost, so we want to make sure that we're not just handing out money. We want to make sure everything's good to go.
Okay, Ms. Renard, and you said that Mr. Donaldson had a policy with you. When did he create that policy?
Back in 2005.
And how much was that policy worth?
$5 million.
Who was the beneficiary of that policy?
Karen Baja.
What about the plaintiff, Cam Donaldson?
No, it was just Ms. Baja.
Let's talk about what you reviewed in reviewing this claim. Can you tell us what materials you looked at?
Yeah, so I looked at Mr. Donaldson's will. I also spoke to several witnesses.
And are materials like that things that forensic document examiners typically look at in reviewing a claim?
Yeah, that's pretty common.
Were you able to come to an opinion as to whether or not to pay out Ms. Baja's claim?
Yeah, I mean, I came to the opinion that there's no grounds to contest the payment.
Let's talk about how you came to that opinion. You said you spoke to witnesses. Who were those witnesses?
Well, I talked to Samantha Lane for one, and Ms. Baja.
What did you learn from your conversations with Ms. Lane and Ms. Baja?
I learned that Lou Donaldson did in fact sign the will.
Let's talk specifically about your conversation with Ms. Lane. How did you meet with her?
Yeah, I met with her in person. She came into the office and we spoke.
What did she tell you?
She told me that he did sign the paper, that he did sign the will, excuse me.
Is that the only time that you spoke with Miss Lane?
The only time I spoke with her. Yeah.
Do you ever receive a letter from someone claiming to be Samantha Lane?
Yeah, I did.
What did that letter say?
That letter said that it was fraudulent, that he didn't actually sign the will, that she was forced to do it, something like that. But I dismissed it.
Were you able to verify the address that that letter came from?
No, I wasn't.
Were you able to confirm that Samantha Lane sent that letter?
No, I wasn't able to confirm that.
Did you take any steps to figure out who sent this letter?
Yeah, I did reach out to Miss Lane, but I didn't hear back from her.
So ultimately, what did you do with this letter?
I dismissed it.
Why?
Well, I couldn't verify anything, and I typically rely on spoken word as an insurance claims processor.
Now, I'd like to talk to you specifically about the signatures you looked at in this case. Your Honor, permission to screen share what plaintiff has already moved into evidence as Exhibit 4?
You may.
Miss Renard, what is Exhibit 4?
Yeah, this is the signature comparison form that I created when investigating this case.
And can you explain to the jury what these 3 signatures are?
So the first one was Lou Donaldson's signature on his life insurance paperwork back in 2005. The second one is his driver's license. The last one is the one that's in contest, the one on his will.
I'd like to start by talking about just those first 2 signatures that aren't in dispute. Are they identical?
No.
Wouldn't you expect them to be identical if they're by the same author?
No.
Why not?
Well, there's a lot of reasons that someone's handwriting can change throughout the years. It could be, health. It could be just the type of pen they're using, how quick they were writing it, things like that.
I'd like to now bring up that third signature, the signature on the will. You notice some differences between the 3 of these signatures.
Yeah, each one has a difference from all of them.
And do these differences, do that mean that this must be a forgery?
No.
Are there similarities in these signatures?
Yeah, there's similarities.
Thank you, Mr. Jones. If your opinion was basically it's inconclusive, there are similarities and differences, why did you ultimately pay out this claim?
Since it was inconclusive, I couldn't determine whether it was genuine or non-genuine. That was basically my ultimate opinion. There's no reason to not pay out.
And did the defendant pay you to write your report in today's case?
No, I mean, I work for the insurance company. My job is to investigate for that business. I mean, it would make more sense if I didn't pay out.
Nothing further, Your Honor.
Cross-examination.
Yes, Your Honor. Now, Ms. Renard, the defendant had Mr. Donaldson declared legally dead on August 18, 2017.
Yeah, that was about 5 years after I believe he went missing.
The defendant filed her claim with Summit Life Insurance the very same day.
That's correct.
And you were assigned to investigate her claim.
Yeah.
During your investigation, you contacted the sheriff's office.
Yeah, I have a good buddy down there.
But the sheriff's office refused to give you any kind of information.
Any kind of, anything about their investigation specifically, but I was able to talk to a friend about it.
Now, you claim that you have a friend that you talked to at the sheriff's office. And they shared information with you, correct?
Yep.
But Ms. Renard, in your report, you did not mention that informant's name, did you?
No, I didn't give the name.
You did not list any contact information for that person in your report.
No, but they work at the sheriff's office. That's pretty easy to get.
You did not say in your report where that information, or where that informant got their information from.
In my 2-page report, no.
And you based your opinion on the information this informant gave you?
No, I based it on a lot of other things.
Right, but one of this, or the information that this informant gave you, went into your opinion.
It went into it, yeah.
So You did all this even though the sheriff's office refused to show you even a single shred of evidence?
What do you mean?
Ms.
Like-
Renner, you filed a formal request for evidence with the sheriff's office and they refused that request. They wouldn't give you anything
That's right.
because this investigation is still active.
Right, but they also hadn't listed her as a suspect, so I didn't have any reason to believe.
Is that a yes, this investigation is still active?
Yes.
Let's talk about the signatures you examined. You reviewed 2 known signatures of Mr. Donaldson.
Yes.
One of those was the signature on his insurance policy,
Yes, that's correct.
and the other was the signature on his driver's license.
Yes.
Now, you took those 2 known signatures and you compared them to the question signature in the will.
I did, yeah.
Your Honor, may I screen share may I publish Plaintiff's Exhibit 4, the signature comparison chart?
You may.
Ms. Renner, can you see Plaintiff's Exhibit 4?
I can, yes.
Now, down here at the bottom where it reads question signature, this is the signature for Mr. Donaldson's alleged will, correct?
Yes, that's correct.
And Ms. Renner, you are aware that the defendant is claiming this question signature is actually Lou Donaldson's.
Claiming that it's actually Lou Donaldson's?
Yeah, she's claiming that Lou Donaldson signed, that's Lou Donaldson's signature.
I mean, yeah, I have no reason to believe otherwise.
And Ms. Renard, after comparing this question signature with the 2 signatures we know are Mr. Donaldson's, you were not able to determine if the question signature was actually Mr. Donaldson's.
But I also couldn't say it wasn't not his.
Exactly, because your results were inconclusive.
Yep.
There were just not enough similarities for you to have a conclusive finding.
No.
In fact, you believe it is possible that someone else signed this will.
Possible, but unlikely.
But still possible, Miss Renard.
Possible, but unlikely.
All right. So as an expert forensic document examiner, you cannot tell this jury that Mr. Donaldson signed this last will and testament.
I mean, I can't tell them that he didn't either. Like I said, it's inconclusive.
Okay. But you've also said that it is possible that someone tried to copy Mr. Donaldson's signature.
It's possible.
The will produced by the defendant was allegedly witnessed by 2 people.
Yeah.
Let's talk about those witnesses. One of them was the defendant.
Yes.
But the defendant was a beneficiary to the will.
She was.
Actually, the defendant was the only beneficiary to the will.
Yes.
So, Ms. Renard, obviously the defendant had an interest in this will.
Yeah, that's right.
And it is unusual for a beneficiary to be a witness to a will.
Unusual, but in my 20 years of experience at the life insurance company, it happens.
Well, you've actually said that it's disfavored.
It is disfavored, yeah, but it still happens.
All right. Now, the other witness was Samantha Lane.
Yes,
And during your investigation, you received a letter from Miss Lane.
I did.
Miss Lane told you that she did not witness Mr. Donaldson sign the signature or sign the will.
Well, I can't verify that it was Miss Lane.
All right. Miss
Verify.
Leonard, the letter said that Miss Lane did not witness Mr. Donaldson sign the will.
Yeah, but I dismissed it because I couldn't verify anything about it.
The letter said that Miss Lane told you that she was coerced into signing the will.
The letter did say that, yeah.
You did not speak to Miss Lane about her letter.
Well, I tried to get in contact with her, but I couldn't find her.
All right, Miss Renard, you did not talk to Miss Lane.
No.
Because you could not find her.
That's correct. I couldn't get in contact with her.
After you talked to the defendant.
Right.
All right. So you never asked Miss Lane how she was coerced.
like I said, I couldn't talk to her.
You did not ask Miss Lane if the defendant threatened her.
No, I didn't ask her anything because I couldn't get in contact with her.
That's right. You just called the defendant and asked her about it, didn't you?
I tried to get in contact with both of them.
You tried to get in contact with Miss Lane. You couldn't get in contact with Miss Lane, so you called the defendant.
Yeah, that's pretty typical. We want to talk to both of the witnesses on the document. That's what I do.
Right, but you tried to call the defendant before you reached out to Miss Lane, didn't you?
I mean, as an insurance investigator, that's pretty typical. I talk to both people.
Okay, let's talk about the language in the alleged will. Not only was the defendant named sole beneficiary, she was also named sole executor.
Yeah, that's correct.
If Mr. Donaldson should die or disappear.
Yeah, I did think that language was a little suspicious at first, but the rest of my investigation told me it really wasn't much to look into.
Okay, well, you would agree with me that the language about disappearing is strange, right?
Yeah, it's not common. I've never seen language like that in my 20 years.
Exactly. You've been a forensic document examiner for 23 years.
That's correct.
You have reviewed hundreds of wills.
I have.
But you only find it a little suspicious that the will contained any reference to disappearing?
I did find it suspicious, yeah.
All right. This is the first time you have ever seen the language, should I die or disappear, in a will before?
Yeah.
Then, Miss Renard, it just so happens that Lou Donaldson disappeared, didn't he?
That is true. Well, possible. Yeah.
No further questions, Your Honor.
Any redirect, Ms. Doig?
Yes, Your Honor. Miss Renard, could the signature on that will be Mr. Donaldson's?
Definitely. That's why we paid the claim.
Nothing further.
Thank you, Ms. Renard. Any additional witnesses for the defense?
No, Your Honor. At this time, the defense rests.
I presume that you renew your motion, and I'm going to save you the effort, and I'm going to deny it, given our forum here.
Your Honor.
You're welcome. I would imagine, we'll go ahead and go off the record for a moment, that people would like a time check before closing arguments to see where we're at.
Yes, Your Honor.
Okay. And I believe we have some witnesses specifically who were keeping time. So if we can go ahead and get a time check from both of them and do a little comparison on that.
The plaintiff will have about 17 minutes for their closing.
Okay. And for defense?
About 25.
So no concerns. Great. Does anyone need a brief recess before we go to closing arguments?
No, Your Honor. The defense is ready to proceed.
The plaintiff is ready to proceed also.
Our jurors, I assume, good to go?
Good to go, Your Honor.
Great.
I mean, stay.
Good point. That was not the best worded question. Ms. Hanselman, are you ready to proceed as well?
Yes.
Good to go. Great. All right. Whenever you're ready, Ms. Stoic, the well is yours.
I believe the plaintiff will be starting.
Thank you. That's what I meant. Ms. Hall, please go ahead.
May I save whatever time is remaining at the end of my closing argument for rebuttal?
You may, ma'am.
When faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. She killed her husband to keep her status, killed her husband to keep his business. She killed her husband to keep his money. The defendant's greed led to Lou Donaldson's death. The defendant's greed led to Cam Donaldson's grief. This defendant planned and intentionally caused Lou Donaldson's death, and she does not deserve to get away with it. Now, The defendant had Lou Donaldson declared legally dead on August 18th, 2017. As the plaintiff, we bear the burden of proving to you, by the greater weight of the evidence, that it was the defendant who killed Lou Donaldson. And we told you from the beginning that Mr. Donaldson's body was never found. But that doesn't mean that the defendant can get away with killing Mr. Donaldson just because she got rid of the body. We have proven by overwhelming circumstantial evidence that it was the defendant who intentionally caused the death of Lou Donaldson. And really, circumstantial evidence is just common sense. It's like the man stranded on a deserted island for months, never seeing another living soul. Now, one day as this man is walking along the beach, he sees a human footprint and he faints. Why did he faint? Because he knew what that footprint meant. He was not alone. That man did not have to see the other person to know that he was no longer alone, because that footprint provided circumstantial evidence. It's just common sense that another person was on the island. And that's why the judge will tell you that the law makes no distinction between the effect of direct evidence and of circumstantial evidence. We have shown you 3 reasons why we know the defendant killed Lou Donaldson. First, the defendant's actions on August 19th and the days that followed. Second, the defendant's will that she produced. Third, the defendant's threats. First, let's take a look at the defendant's actions, starting with the early hours of Sunday, August 19th, 2012. At 3 o'clock in the morning, the defendant claims that she was out buying milk and just happened to leave her phone at home. So who does she call when her car breaks down? Her brother, not her husband. Why didn't she call her husband? She claims that she was not sure if he was home, but we all heard Cam tell us today that her father invited her to dinner on Sunday night. You see, Mr. Donaldson was not planning to go anywhere, not planning to take any trips. He was planning to be home. But the defendant did not even try to call her husband. Why not? Because she knew he could not answer. And then at 6 o'clock in the morning, just a couple of hours later, Cam sees the defendant coming out of the office at Wild Wildlife with a man Cam had never seen before. Who was that man? It had to be the defendant's brother. She had just called him a couple of hours earlier. Now, why is it important that the defendant and her brother are not only together in the middle of the night, but also at Wild Wildlife before 6 a.m.? It's important because it takes 2 people to use the meat grinder at Wild Wildlife, 2 people to put a human body inside. The defendant had the means to dispose of Mr. Donaldson, and she also had the help. Now, of course, the defendant says that there was no human blood found on that grinder, but the defendant's brother works for the sheriff's office. He would know how to clean up any trace of blood, and they had plenty of time to do it. 3 hours from 3 a.m. to 6 a.m. You see, the defendant knew that without her cell phone, her location could not be tracked. Nobody would know where she was for those 3 hours. You know who else nobody could know? You know who else nobody could track for those same 3 hours that very night? Her brother. Why? You heard in his testimony that the transponder in his vehicle just conveniently stopped working. That was so nobody could track his location as they were disposing of Lou Donaldson's body. Most telling is the defendant's reactions when the police tried to question her. I'm the owner of Wild Wildlife. If you have any questions for me, you can contact my attorney. Why did the defendant lawyer up? What did she have to hide? Why not just tell the police you were out getting milk for your cubs and you locked your keys inside. Why not explain what was going on? Explain what you were doing. The same reason the defendant was claiming to be the owner of Wild Wildlife before anyone even knew that Lou Donaldson was missing. Because this defendant, she knew Lou Donaldson was dead, and she did not want the police snooping around that meat grinder. Now, the defendant's actions in the days after that Sunday also proved the defendant killed Mr. Donaldson. The defendant claims that she held out hope for 5 years that Mr. Donaldson would come back. But it was not even 5 days before she fired his daughter. You see, the defendant knew how close Cam and her father were, that they had worked together for 20 years. There is no way the defendant fires Cam just a few days after Mr. Donaldson disappears if she thinks there is any chance Mr. Donaldson is going to walk back through that office door. She fired Cam because she knew she could, because she knew that Mr. Donaldson was not coming back, because she knew that Lou Donaldson was dead. The second reason why we know the defendant killed Lou Donaldson is the will the defendant produced. This will left the defendant everything, and Cam, nothing. You see, this is not the will of a man who worked side by side with his only child for 20 years. This is not the will of a man who had his daughter, not his wife, run all of his finances. This is not the will of a man who had the type of close relationship with his daughter we heard so much about today. This is not the will of a man who had a $5 million estate. Because let me tell you what, no one worth that much money is going to use a legal Zoom form like this one and claim it's their will. This was not Lou Donaldson's will. This will was clearly a forgery. Now, Chris Renard, the defense's witness, said that she could not determine if the will was a forgery, but admitted that there were several differences during cross and ultimately said that her results were inconclusive. But really, we do not need an expert to see that this signature is not the same as Mr. Donaldson's known signature. I mean, just look at them. Anyone can tell that this questioned signature is not the same. But we did have an expert, Taylor Pride, and he confirmed for you today that this will is in fact a forgery. Now, we also know this will is a forgery because the defendant actually wrote that she would become sole executor if Mr. Donaldson should die or disappear. And what do you know? That's exactly what she's claiming today, that Mr. Donaldson disappeared. But both Taylor Pride and Chris Renard said that in the hundreds upon hundreds of wills that they have investigated, they have never once seen the term disappear in a will before. Of course they haven't. People write wills to plan for their death because everyone knows that they will eventually die. No one writes a will to plan to disappear. No one plans to disappear at all. This will is clearly a forgery. Now, there's one more thing that proves that this will is a forgery. This will was dated June 14th, 2012. We heard today that Mr. Donaldson petitioned for a restraining order on June 12th, 2012. So essentially, what this defendant is wanting you to believe is that 2 days after requesting a restraining order, 2 days after saying he was scared of the defendant, 2 days after he said the defendant threatened his life, he went out and wrote a will leaving everything to the defendant. That does not make any sense. Why would Mr. Donaldson change his will to leave everything to the defendant 2 days after he files for a restraining order because he's scared of her? The will is clearly a forgery. It went off, but everything about this will proves that the defendant killed Lou Donaldson. And that brings us to the final reason why we know the defendant killed Lou Donaldson: the defendant's threats. We know from the restraining order that the defendant threatened to kill Mr. Donaldson in June of 2012. Cam told us that after that, just 2 weeks before Mr. Donaldson disappeared, her dad again asked for a divorce, and that the defendant was furious, screaming, yelling, storming out of the office. And moments later, Mr. Donaldson came out of his office, upset, scared, shaking. And looking at Cam, his only daughter, he said, "If anything ever happens to me, Cam, have the police look into the defendant. She will be responsible for my death." And she was. The defendant even admitted to Exotic Bob that she killed her husband and used the meat grinder to dispose of his body. So, just like that footprint on the beach proved that the man was no longer alone on a deserted island, the defendant's actions on August 19th and the days that followed, the will the defendant produced, and the defendant's threats and just plain old common sense prove that the defendant intentionally caused Lou Donaldson's death. And in doing so, caused Cam Donaldson's injuries. See, Cam's injuries were far more than the loss of her inheritance. Cam lost the man she worked side by side with for 20 years. Her friend, her father. And the grief, pain, suffering, emotional, and even physical stress that comes with the untimely loss of a parent leaves a hole that can never be filled. Their absence is not just felt on the holidays when you can expect for families to gather, but in the small moments. No more picking up the phone to call him. No more goodbyes when leaving the office. No more Sunday dinners. Cam Donaldson will suffer these injuries every single day until her last. Now, the judge will give you this verdict form, which fines for Cam Donaldson and awards her money damages. And as much as we wish we had a time machine so that we could go back in time and prevent this heinous act from ever occurring, we don't. And monetary damages are one of the ways in which our legal system can compensate Cam for her injury, for Cam's loss. Considering the size of her father's estate, we suggest you award Cam at least $10 million. Because when faced with losing everything, some people will do anything. When this defendant was faced with losing everything, she did the wrong thing. She killed her husband to keep her status. She killed her husband to keep his business. She killed her husband to keep his money. And she does not deserve to get away with it. Don't let her. Fine for Cam Donaldson.
All right. Thank you, Ms. Hall. Defense closing argument, Ms. Joy.
One moment, Your Honor, if you don't mind, if I just set up this camera.
No, go right ahead.
Fact. Lou Donaldson disappeared 8 years ago. Fact. 5 years after he disappeared, Ms. Baja filed for his inheritance. Fact. Lou Donaldson's death was a tragedy. Fiction. Karen Baja put her husband through a meat grinder. Fiction, Karen Baja fed Mr. Donaldson to the lions and tigers on their property. Fiction, Miss Baja is liable for wrongful death. Fortunately, courts are for facts, not for fiction. No one feels the loss of Mr. Donaldson more than Miss Baja. She wakes up alone in the bed that they used to share, as she goes to work on the property that they used to work together every single day. She sits here today, in a defendant in a court case filed by her own stepdaughter, and has to listen to a fantastical story about a wicked stepmother who killed her husband and fed him to the hungry animals. Wow, this makes a great plotline to a children's book, or even a Netflix series. Doesn't make sense in real life, and certainly not in a court of law. Because in a court of law, you can't just come with a story. You need the facts. And the plaintiff, since they brought this case, they had the burden of proof to prove their case to you today by a preponderance of the evidence. They didn't meet that burden. That becomes clear when we revisit those 3 facts that my co-counsel, Mr. Dorash, told you about at the beginning of today's case. That's the first fact. Karen Baja did not kill her husband. Second, it is more likely that Lou Donaldson died in a plane crash. And third, Lou Donaldson's will ensured that wild wildlife was always taken care of. Let's talk about that first point. Miss Baja did not kill her husband. What the plaintiff tried to tell you today is that this woman had such a masterful plan that her husband disappeared without a trace of evidence. Out of desperation, the plaintiff hangs their hat on the word of a man named Exotic Bob, who's in federal prison. We all saw the video, and members of the jury, I can admit, that was funny. And Exotic Bob, he can certainly sing and play the guitar better than I ever could. But are you really going to trust the word of a man named Exotic Bob, who's in federal prison, and blames Miss Baja for him even being there in the first place? Brings me to my second point. The evidence shows that Mr. Donaldson more likely died in a plane crash. The evidence you saw today wasn't a DNA test linking Miss Baja to the crime, wasn't an eyewitness saying she did it, wasn't even a body of Mr. Donaldson that could prove he was killed by Miss Baja. What we heard today is that Mr. Donaldson's plane was found at an airport. What we heard today is that Mr. Donaldson's a pilot who would often fly at a moment's notice. His own daughter even admitted today that he often wouldn't log his flight plans, which means that authorities tracking the planes weren't tracking Mr. Donaldson and wouldn't be able to tell if he reached his destination safely. Miss Baja even admitted to us that she knew her husband was having an affair, the woman that was living in Costa Rica. She knew that Mr. Donaldson would take that plane to go visit that woman in Costa Rica. Members of the jury, it's more likely that the reason his van was at that airstrip, his plane gone and him gone, because he got on that plane. Something happened along the way. Of course, the plaintiff repeatedly told you about the temporary restraining order filed by Lou Donaldson. They want you to believe that because Miss Baja and Mr. Donaldson were having problems in their marriage, then of course Miss Baja killed him. They even went so far as the plaintiff came here today and told you a story about how her father told her that if anything was to happen to him, to have the police look at Karen. Members of the jury, how is that story to be believed? If the plaintiff and Mr. Donaldson were as close as the plaintiff claimed they were, wouldn't she be a little more concerned? Maybe ask a follow-up question, maybe pick up the phone and call the police right then and there? Or better yet, the plaintiff claims that just a few weeks later, she saw Karen Baja break into wildlife, steal her father's will, and the police were there. So wouldn't she then say, hey, officer, my father is scared of Karen Baja. My father has disappeared in Karen Baja, and he told me to tell you to look into Karen. Wouldn't the plaintiff at least say that woman has my father's will? She didn't say any of that. I could tell you what that says about the plaintiff's credibility, but I think you already know. My third and final key point. Lou Donaldson's will ensured that wild wildlife was always taken care of. I heard today that Miss Baja loved those cats at Wild Wildlife, and so did Mr. Donaldson. They had worked together doing this unique occupation, caring for wild animals, for 11 years. Mr. Donaldson knew that his wife loved those cats just like he did. He knew that his wife had the same dreams that he did. This is why he wrote his will, giving his estate to her. When Mr. Donaldson disappeared, Miss Baja didn't run off with his millions of dollars. She stayed where she had always been, a wild wildlife, taking care of the animals and keeping Mr. Donaldson's legacy alive every single day since he disappeared 8 years ago. Now, of course, the plaintiff says, but our expert says this will is a forgery. So the jury, I want to remind you of the circumstances surrounding Mr. Pride's hiring. Miss Baja presented Mr. Donaldson's will back in 2012. The plaintiff didn't hire someone to look into it in 2012, didn't tell Mr. Pride that she thought this will was forged in 2012, never even claimed that a prior will existed, never told Mr. Pride that. Didn't claim that until today. And she didn't get Mr. Pride involved in today's case until 5 years later, conveniently, right before Miss Baja was to receive the inheritance of her husband's will. We heard from another expert today, and members of the jury, there's something kind of unique about Chris Renard. You see, Miss Renard wasn't hired because we asked her to, or because Miss Baja paid her to be here. Miss Renard did an independent investigation for Summit Life Insurance Company. And Summit Life Insurance Company, they might actually have a reason to not pay out this claim. After all, if Miss Renard didn't pay this claim, she would save her company millions of dollars. She ultimately decided they should. And why is that? She told you today that, yeah, there are some differences in the signature. There are also a lot of similarities. And that the differences she saw were more likely just due to age of the signer or the speed of the signing. Members of the jury, the reason we can trust the word of Miss Renard over that of Mr. Pride is because when Miss Renard had money on the line to say this was a forgery, she didn't. Grief is a complicated thing. And both the plaintiff and Miss Baja, they have every right to grieve Mr. Donaldson's loss in their family. This trial, this lawsuit, this goes far beyond grief. The plaintiff has stomped on her father's wishes, smeared Miss Baja's name, and demanded millions for herself under the guise of justice. But I guess it's just as the plaintiff said. Some people, when faced with losing everything, will do anything. When the plaintiff learned or believed she was cut out of the will, wasn't receiving any of his inheritance, that's what she did. At the end of today's trial, during deliberations, you're going to have a choice. You're going to see two different forms. One form will allow you to give the plaintiff money, and the other form, it won't. As you look at these two forms side by side, I want you to remember what was fact in today's case and what was fiction. If you believe that what the plaintiff is asking you to do is found in their favor without the evidence, you must use that second form. This is my last opportunity to talk to you. As the plaintiff has the burden of proof in today's case, they get the final word. Make them answer the questions that they've left unanswered. Make them tell you how you can trust the word of a man named Exotic Bob. Make them explain how Miss Baja can be liable for her husband's death when there's no physical evidence connecting her to it. Make them explain where Mr. Donaldson went if he didn't get on that plane and his car was found parked at an airport. And we know that he's a pilot. When those answers come, if they come at all, and they're fiction, they don't persuade you, tell the plaintiff that. Tell the plaintiff that courts are for facts and not for fiction. Because even though the plaintiff gets the final word right now, ultimately, members of the jury, you have the final word. Or in today's case, the final 2 words, not liable.
All right, thank you, Ms. Joy. Ms. Hall, I believe you have 2 minutes and 15 seconds.
Yes, Your Honor. Now, the defense has tried to downplay the will this entire trial. Why is it important that the defendant forged this will? Because Mr. Donaldson's estate was worth $5 million. And that gives this defendant 5 million reasons to kill Lou Donaldson. You see, the defendant knew Mr. Donaldson wanted to divorce her and knew that if he did, she would get nothing. But if she killed him and forged a new will, she would get everything. And that's just what this defendant did. The defendant's threats, the defendant's actions, the night Mr. Donaldson disappeared, and this forged will are all facts. And the claim that this defendant didn't kill Mr. Donaldson, forge his will, and then take the entire estate and all his money is fiction. Fine for Cam Donaldson.
All right, thank you, Ms. Hall, and thank you to everyone. We will go off the record at this time. Congratulations, you all. Wonderful job.
Thanks, Your Honor. Great job, everyone.
Thank
you guys.
That was such a solid round. Really, really nicely done. Hello, Mr. Nibs.
Hello.
I know we're not giving any major feedback, but is there anything